Judgment.
Oh, yes.
41.
Petition is allowed, the proceedings are quashed.
Obliged. Item number 43 in the supplementary, my lord. On the last occasion, my lord, this matter was tagged with another criminal petition 1189 of 2025. That matter have not come, my lord. So with the consent of the other side, my lord, may I pray for fixing it on 10th of this month, my lord?
All right, list the
My lord.
matter on the 10th,
10th of
along with
along with criminal petition number 1189 of 2025.
according on the prayer of learned counsel, the respondent with the consent of the petitioner side.
What? Obliged, my lord.
10th of this month.
May I please tell us? This matter pertains to your bench, my lord. Kindly that my lord, the mother of a 3-child, my lord, is in custody, my lord. I have filed already. Kindly today this matter will be.
Tomorrow.
Yeah, please, Jonas. I beg to mention item number 19, my lord. Case diary has not been received, my lord. Can be another date, my lord.
19.
They did not receive.
26th, my lord. In 6. There is an interim order. Obliged, my lord.
Please, Your Lordship, I beg to mention for item number 24, Your Lordship, as per instructions received, I may be allowed to withdraw, Your Lordship.
20,
24, Your Lordship.
the prayer of learned counsel for the petitioner, Mr.
R. Kumar, Your Lordship.
The matter is dismissed as withdrawn.
Please, Your Honor. I beg to mention for item 7, Your Honor. I'm representing on behalf of standing. Your Lordship, she is unable to be able to due to her personal reason. Lordship, may be pleased to adjourn the matter.
Lordship, I'm appearing for on behalf of petitioner. Lordship, I fix a short date. There is some urgency.
Yes, when?
Tuesday.
Is the matter next Tuesday on prayer of learned counsel for respondent and with the consent of the other side.
May it please, your Lordship, I beg to mention item number 10, Lordship. Kindly matter may be adjourned for a day, Lordship. Mr. P.K. Roy Chaudhary is out of station, Lordship.
For the day list again on.
Please, Lordship. Please, your Lordship. Lordship, I beg to mention item number 44 of the supplementary. The last previous date LCR has been called for, not received yet.
Before. This call for has not been received. List again on.
Well,
May I please, Lordship? I beg to mention item number 15. Sir, case diary has been not received yet. Kindly adjourn for to and list this matter after 1 week.
15.
Yes, sir.
They did not receive list again on.
Highly obliged.
May I please, Your Lordship? Lordship, with the consent of other side, I beg to mention item number 28, my lord. It's a bail hearing matter, my lord. Perhaps case diary is not received.
They did not receive list again on.
My lord, there is an interim order, my lord. That may kindly continue.
The order passed earlier. Continue.
Deeply obliged.
May I please, your Lordship? I beg to mention item number 20, my lord. To withdraw this matter, my lord, we'll file in the lower court below. My lord.
Huh?
When to withdraw this matter, 20.
The prayer of Mr.
Ibora, my lord.
Matter is dismissed as withdrawn.
Approach the lower court below, my lord. Obvious.
Is this matter? This matter was reserved for judgment. However, going through the record, I'm not inclined to the matter. Accordingly, the same is released. Release the matter for hearing before another bench without me.
Obvious, my lord.
May it please your lordship. The petitioner, in this case, the petitioner has been in judicial custody since 24/12/2025. On 26/12/2025, the charge sheet has been submitted and the case is pending as session case num 4/26. Hence, further custodial intervention is not required. Your lordship, the prosecution case rests entirely on an alleged promise of marriage. It is respectively submitted that the informant was a legally married woman at the relevant time. Therefore, no valid or lawful promise of marriage could have existed in law. The materials on record show that the informant voluntarily left her matrimonial home, traveled to Kerala on her own, and resided with the petitioner out of free will and consent. There is no contemporaneous allegation of force, coercion, or threat. Your lordship may kindly consider the conduct of the informant. She early filed a 498 case, 498 case, failed to pursue it, allowed it to be dismissed for non-prosecution, thereafter lived with the petitioner and again left the relationship. This conduct directly affects the credibility and a relevant consideration for bill.
Your lordship may kindly peruse page 38, third paragraph, ma'am.
After the charge sheet has been filed, one bail application has been rejected by Additional Session Judge Morigaon. Your lordship, petitioner has no criminal incident, is a permanent resident, and no likelihood of absconding or tampering with the evidence. At any condition, you may kindly be allowed to go on bail.
We'll have the scan copy. The charge sheeted matter call for the scanned copy of the TCR along with the CD. Begin on.
Pass of login.
May I please your lordship? Lordship, this is my second regular bail application, lordship. Earlier, it was rejected by this honorable court, lordship. Lordship, I am in judicial custody more than 231 days, lordship, and I am charged with mainly section 1031, lordship. Translated copy of FI is page number 16, lordship.
Well, we need the CD. We have rejected earlier. Charge sheeted.
Lordship, I have a submission, lordship. Lordship, Lordship, I am the father of a minor Sikh girl, Lordship.
Have it searched. Same order. I got to order.
25. 20. 12. 12. 12. Published.
Wait, please, your lordship. The applicant before your lordship is arrested under the section.
Fixed currency, my lord.
Fake currency, it is Wildlife Protection Act 9. Item number.
Right, let's have the CD.
94450 of Wildlife Protection and 52 of Wildlife Protection Act of regarding the FIR filed by the Bongaon Outpost, SI of Bongaon Outpost regarding the illegal poisoning and killing of possession and inside the sale and migratory birds of game or goods. And lordship, in this matter, in this bail application, lordship, the applicant.
In this case, my lord, special PP wildlife, I will have to inform.
Lordship, in this.
All right, inform.
After some time, lordship. Wait, please, your lordship. This is the first bail application, lordship. Accused is behind the bar for more than 200 days. FIR is at lordship page 12 to 19, lordship. The gist of the case is that during Naka checking, a vehicle was stopped and some forged and fake currency notes were recovered. Admittedly, I am the driver of the vehicle, lordship. Two other persons who have hired me have a bag with them, and in that bag, some fake currency notes were found, according to the police, lordship. I am no way involved. Trial court has already framed charges, and 4 seizure witnesses have been examined. We have annexed the copies of the witnesses' evidence also, lordship. The witness evidence sheets are, lordship.
Or sheet submitted, my lord, in this.
Charge sheet submitted, lordship. Charges have been framed
Use
at page
quantity
50,
of-
the charge form, lordship.
So if charges have been framed, we must presume there is material against you.
No, definitely, lordship, we are behind the bar for 200 days, lordship. 4 witnesses have been examined, lordship. But the witnesses, interestingly, have categorically stated, lordship, that the bag was recovered from a woman co-accused in this case, lordship. I am the admittedly a driver here, lordship. My vehicle was hired by them, these 2 persons. And during Naka checking, a bag was recovered from them. We have prayed for discharge also, that was rejected. We have annexed the copy also, lordship. Lordship, the page 64, evidence of PW3. Categorically stated, I saw currencies to the hand of the woman accused in a bag. Is a seizure witness, lordship. There are 11 witnesses, lordship. So considering the period of detention and the available evidence, no case is made out practically for custodial trial, lordship.
Huge quantity of fake currency, my lord. Finding materials discharge application was also rejected by the learned.
There should be some role against me. No, nothing indication in the charge sheet also. Simply they have admitted, yes, I am a driver. My vehicle was hired by these 2 peoples and bag was recovered from them.
How can you say there is no role? It was in your possession. All 3 of you were there.
No, I am the driver, lordship. That is the fact. I am a taxi driver, lordship. I used that vehicle belongs to my father, lordship. Police has seized my driving license also. And the evidence of all the four witnesses are before the court. None of the seizure witnesses nowhere involved me. I am ready to face the trial, Lordship, no problem on that part, Lordship. And simple position, even if taken at par, then also the punishment is up to 7 years in 118. Use, no evidence of use. That while handing over somebody,
Page 48, my lord, of the order, paragraph 6, my lord.
now the only question whether custodial trial. I am a local man, Lordship. I will abide by all the conditions, Lordship. With any condition, Lordship, my prayer may kindly be considered, Lordship. And the seizure list also, Lordship, at page 30 clearly shows that bag was seized from Wangnam Mapuk, the lady passenger, against whom the witnesses have deposed, Lordship. That also disclosed one driving license in the name of Santosh Rai. And interestingly, in the seizure list also, Lordship, if I point out, Lordship, at page 31, Lordship, majority of the notes are one side printed. Can it be a fake currency note? That will be a question will come, though they have shown that about 1,500 some notes were seized. But in the page 31 seizure list, out of 65, 35 numbers of both side printed and next others are single side printed. All these are Xerox notes, colored Xerox, whatever I say. Next B, 5 pieces are both side printed and others are single side printed. Next C, 65 numbers, 5 numbers are both side printed, others are single side printed. The amount was shown to have been used. In every bundle, there is 5 or 7 notes. Those are both side printed. But I'm not want to going on the merit of that part, Lordship. Period of detention of 200 days, Lordship. I am behind the bar since 16/7/2025, Lordship.
Where is the charge sheet?
Charge sheet is a page 34 onward, Lordship. Even in the charge sheet, Lordship, at page 44, police has mentioned the number of seized note is 1559. But below 2 paragraphs, the forensic report says 1563. number of notes.
Since they have annexed everything, there is no need to call for the copy, I think. Scan copy.
Yes, my lord.
We have annexed everything. Lord.
So consider on the basis of this only.
Regarding the, my lord, I would just like to point out paragraph 6 and 7 of the, my lord, discharge rejection of the.
Yes, yes.
And thereafter, my lord, regarding one side printed of the some of the fake currency note, this is their tactics, my lord. While carrying all those fake currency note, some of the notes they carrying without only printing one side by that is they trying to point out a case that is a case of, my lord, not fake currency notes. Some of the, my lord, notes are one side printed. Thereafter, along with that, my lord, they are also carrying huge quantity of, my lord, fake currency note. And at this point of time, my lord, while from the facts and circumstances, prima facie material are against the accused person, that can be, my lord, only after the, my lord, detail that if my lord, there is rightly, my lord, therefore, my lord, rejected the discharge application filed by the petitioner, finding strong.
It is certainly not a case of discharge. We are on question of bail now.
That's not challenged here also, Lordship. Even after rejection of prayer, we have not come up before the Honorable Guwahati High Court challenging that order. We are ready to face the trial, Lordship. Only the whether custodial trial, Lordship. This is the only consideration, Lordship.
That is the only consideration, my lord.
But in the even at page 44, police stated that I am the driver. That has been mentioned in the charge sheet. I am the driver, and the note have been seized by bag has been seized. That has been the witness, Lordship.
But whereas because these are economic offenses, so, my lord, length of detention also, my lord, at this.
It is 6 months, 200 days, Lordship. More than 6.5 months.
Yes.
Obliged.
Stated case, my lord,
Yes, ma'am.
NDPS commercial.
Only. Scan copy of TCR. Yes.
But can it be 24th or 25th of February, man? Kindly, madam.
Why?
Second March will be after a week, after a month, madam. 4th week of February, man.
February 2nd, 4th, many other cases already fixed on the 5th, 26th.
In the March commercial quantity.
May I please, your lordship? My lord, the petitioner were arrested on 24 January, my lord. It's 13 days and case registered under section 21B of NDPS Act, my lord. Case diary may be performed here.
CD.
I am blessed.
Your Lordship, 483 bail application. Your Lordship, the petitioner is in custody since 36 days, Your Lordship, 31st of December 2025. And recovery has been made, Your Lordship. Page number 18 is the seizure list, your lordship.
This quantity of material.
Yes.
CD.
Lordship, he was not aware at the time he was the driver, your lordship, and other co-accused had been
But he's
granted bail,
aware.
your lordship.
All right, CD.
Oblige, your lordship.
Right, my lord, lordship will find, my lord, the affair at page 14. Now, both the, my lord, petitioner and the, my lord, victim, they used to work in the, my lord, social media by making, my lord, videos, dramas, etc., and uploaded in the YouTube and Facebook. Now, suddenly, my lord, her mother lost the affair after 1 month, saying that my daughter is missing. And accordingly, my lord, the petitioner has been arrested and he is in custody for about, my lord, today 33 days. We have annexed the, my lord, forwarding report. There is no kidnapping. Victim is with the mother at present.
What is the meaning of the word CLOW?
Oh,
Page
so
10.
my lord, we are extremely sorry, my lord. We will
pages.
file the, my lord, correct type, my lord. There is some, my lord, typical error.
9 AMA.
I will furnish the, my lord, correct type, my lord.
Yes, call for the CD.
Or date may be given, my lord. 26. Oblige, my lord.
Your lordship. My lord, this is a POXO case, my lord, sections 4 is there. And at the time of framing of
6 March. Oblige, Your Honor.
May I please, your lordship, 482 application, lordship, FR is page 10, lordship, may I read, lordship? FR page 10, lordship, may I read, lordship?
Yes.
Humble summary is that I, Srimati Manasi Datta, age 25 years, wife of Pranjal Datta, resident of Dergaon, Third Gate, PS Dergaon district, Golaghat. My mother house is at Khelmate, Jorhat. My husband work as carpenter. He is currently in Dimapur. He left me at my mother house 2 weeks ago before going to Dimapur. Yesterday on 17/8/2025, while I along with my sister-in-law went out for searching work at Bangalpokuri, I meet Partha Datta. Partha Datta is a present petition before lordship, whom I know since earlier. He said that he will take me to a temple and send my sister-in-law in house. Till evening at 6 p.m. he roamed me on his scooty in the town. And after that, Partha Datta took me to one of his friends who is working at Jorhat Mission Hospital. At night around 9 p.m., Partha Datta went out from the house to bring something from shop. After he left his friend forcefully committed rape on me. Somehow I pushed him and went out from his room. When I had left, the local inhabitant of Mission Hospital campus saw me and handed over to Rauria police. Here in this case, lordship, there is no any allegation against the present petitioner. Lordship, this is a co-accused again, and on occurrence, lordship, he was not present, lordship. Thereafter, the concerned police of Jorhat police, lordship, arrested co-accused, lordship, one Vedanta Datta and Manjul Datta. Thereafter, they approached the learned trial court for preferred regular bail application. Kindly see the page 18 is the water copy of bail application of co-accused, lordship. Here is the victim 160%, especially implicated one of the co-accused, lordship, Vedanta Datta. And there, as you kindly see page 18, lordship. Is a water copy
Who
of
are
the
you? How are you connected?
lordship, because he is earlier none of the said victim, and he is the painter, lordship, and his husband is the Pakka Mistri, lordship. And in this connection, he earlier none the petitioner, lordship. Thereafter,
on the said occurrence, he herself contact the petitioner regarding the search of work, lordship. Thereafter, he request him to go to the temple and her voluntary requested he went and roamed in the city town, lordship. Thereafter, he went to some fresh up and he took to his friend house, and the told that he voluntarily went to the house of the friend of the
Your Lordship, may
petitioner.
kindly peruse page 18, second and third paragraph, my
Lordship,
rejection order of the learned trial court. my lord.
there is sufficient income material against the accused Vedanta. Petitioner is not Vedanta Dosto, and and Montu, he is not Montu Dotto. Vedanta who commit the and on 64 also implicated the victim, the Vedanta Dotto, not present. There is no illegal allegation in the present petitioner.
I don't know. Because that application was in respect of Vedanta Datta.
But in her
The court has said that he has implicated accused Vedanta Datta.
but in her in 61 to implicate the accused Vedanta, but there is whether there is a co-accused and Montu Datta is also is in present. He is allowed go on lordship.
Who is Montu Datta?
Montu is one of the accused who was also present on the date of occurrence in that house, lordship. Their name is not mentioned, lordship.
But it was you who took her to that house.
Lordship.
So you have a clear role.
No, lordship. I have no on the date of if FIR itself says that I am not present on that.
Not a fit case for
lordship.
interim bail.
Kindly take the protection, lordship. In the meantime, he will cooperate, lordship. He will record his statement before the police, lordship. Then kindly, lordship, he is not role in that. There is no any allegation of abatement, lordship.
Yes. 22.
May I please, Your Lordship? My lord, it's a 482 application for a pre-arrest bail. The petitioner, Okondas, is a central room operator of one grinding unit of the Star Cement Factory. Well, this 7 months back, what happened? An incident, some misses happened. One assistant engineer and the 5 person who were working together, they suffered some injuries and suffocation because of the some stopping of the fans, my lord, in the inside the factory, my lord. Thereafter, my lord, out of that 5, the assistant engineer who was looking after the working at that relevant point of time, he suffered death, my lord. And thereafter, my lord, there are some, as far as the norms of the Factories Act, we have given the compensation, my lord, that is page 29, my lord. Assistant Labor Commissioner accordingly granted the 32,85,000 to him, and the father of the deceased, he has received the amount also on 17/7/2025 by the order of the Labor Commissioner, my lord. Thereafter, my lord, the father, after received of that amount, he lodged an FIR to the police station, the same police station, my lord. Thereafter also there are some, apart from that, he has received another 30 lakhs from the company, my lord. That is on 25/8/2025. And we have also annexed that 2 checks which received by these 2 sisters of the deceased. Thereafter, my lord, on 27/8/2025, lordship, kindly see page 61. The father, after receipt of all the amount, he has withdrawn the first FIR, that is in page 61. Withdrawal of the petition filed against the so-and-so limited on 4/8/25. The second paragraph, after having discussion with the official Star Cement Limited, I came to understand that the incident was purely an accident and there was no negligence or fault on the part of the Star Cement or any of its representative. Now, accordingly, my lord, he has withdrawn his earlier FIR, which is registered as GD entry
Thereafter, there is a report, my lord, lordship kindly seeks page 66 of the IO. That's very important. Relevant, which starts from 66, a detailed report regarding the withdrawal of the FIR and the incident had happened. Page 66. Lordship kindly see the relevant portion will find at 68. Has your lordship got it, my lord? 68.
Yes.
Second paragraph. During examination of the complaint, accompanying workers, team of the maintenance work carried out so and so in the coal mill reveals some time of statement so and so morning about the total 11 people were working together in coal mill, including the deceased Shiva Tiwari. He was in charge of the group. All safety measures and work permit were under his own responsibility. Group in charge Shiva Tiwari took all the permit job of the team on maintenance were go with the in charge and do work the works against the in charge. Since so and so the working of the coal mills was started. Before that, there was another group who worked for the maintenance, still so and so for safety measures. They were also wearing hand gloves, face masks, helmet, jacket, boot. At around 7 a.m., total 6 people, including Shiva, went inside the coal mill and were changing the plates. After some time, the working team heard the worker, namely Satya Sarkar, was asking Shiva Tiwari about who turned off the fan. Then Shiva Tiwari was talking with someone in mobile phone and he replied that he told the CCR to turn it off. CCR is the petitioner, my lord. Shiva Tiwari did not inform none of them regarding the fan being turned off. Immediately after the fan turned off, a sudden coal dust came inside through the pipe, and inside it turned it dark, and the coal dust started inside their eyes, mouth, and all over the body. Everyone were having the difficulty in breathing, and they were unable to see through the eyes. The door was narrow, and only one people can go through at once. Among them, all of 5 them, excluding Shiva Tiwari, crawled and somehow managed to come out of the coal mill. Shiva Tiwari stuck inside, but later on he was also brought out by the rescue staff, and immediately all of them were brought to the Sonapur district hospital. Thus, the Shiva Tiwari got accidental death. So it is absolutely accidental death, my lord. So accordingly, he has also mentioned that the previous FIR has been withdrawn by the father. Now, my lord, then thereafter, my lord, they have started again demanding money, my lord. Now, the second FIR for the same incident has been initiated. That is page 73, my lord. By the mother this time, my lord. Page 73. And absolutely silent about all the payment, everything. They have received the amount of more than 60 lakhs, my lord. And thereafter, my lord, a notice has been served upon me, page 91, under section 35 of the BNSS, my lord. So I'll cooperate with the investigation, my lord. Until then, I may be protected, my lord.
Case is registered under what section?
Case is registered now on the 105 BNS. Culpable homicide.
Yes, PP.
Yes, my lord, as per from the page 61, it reflects that yes, initially one UD case was registered about the incident that what was happened on 2/7/25, and thereafter, my lord, this petition filed for withdrawal that is there in page 61. Thereafter, your lordship, in page 67, if I am correct, my lord, last portion, my lord, cause of death asphyxia as a result of mortem suffocation, my lord. And thereafter, my lord, in this affair, which the present, my lord, anticipated bail application has been filed in page 85, my lord. Here the paragraph 2, the petitioner, the informant has stated that a week before the fateful day, otherwise, my lord, earlier, my lord, incident already pointed out by my learned senior, my lord. A week before the fateful day on the 2/7/2025, my son Shiva Tiwari told me that he had expressly told to above Mr. Sandeep Sumanta, Mr. P. Mathur, that he is going to resign if other persons Horace work is asked to do other than the job assigned to him. So regarding that aspect, my lord, that is later on, my lord, after that FIR is lodged after those withdrawal of the cases, my lord. Initially, one UD case was registered. Thereafter, considering now the postmortem report as a asphyxia as a result of antemortem suffocation, to, my lord, find out all those cases, my lord, without CD, my lord, at this point of time, my lord, why he apprehends and why, my lord.
Because you
in
have
the-
issued the notice to me.
In the present affair, my lord, he has lost, while lodging this affair, he has written that regarding some other causes may also be there. Those facts. my
I'm
lord,
not
at
named
this
in
point-
that, my lord.
At this point of time, CD is not with us, my lord.
But
Only
as
CD
per the police report itself, he switch off the fan on the instruction of the deceased itself
yes.
himself.
Otherwise, my lord, I pointed out that regarding cause of death is also that is there because of
All
suffocation.
right, we'll grant some interim protection
Yes.
since the FIR was initially withdrawn.
Yes, yes, that is there.
Pass over to solution.
Ablash. Next statement.
Give a date.
Second. Ablash.
That was actually UD case initially on 2/7/2020. Was, my lord, UD case was initially, that was withdrawn later on.
I'm not coming for the quashing of the FIR,
Yes,
my
sir.
lord, as he's
No,
saying
no,
that
I am not.
Let's say you have to point out that your own report says it's a death due to the negligence of the own person, my lord.
Just pointing out, my lord.
You should be fair enough.
Deeply affected.
Also, 483 of the BNHS, your lordship. The I have two accused person, your lordship. One is the lady, your lordship, and the medical documents I have annexed in here, your lordship, of the page numbers. Page number 43, your lordship. And she is suffering different kind of illness, your lordship. She is in
We'll come to the illness later on, but first tell us what the case is.
Lordship, my grounds is here, yes, lordship. They are in custody 171 days, your lordship. And the page number 24, your lordship. Page number 24, your lordship.
At least let us know what are the allegations first, then we'll come to all that.
Allegation is, your lordship, this is the 9.29 grams morphine recovered, your lordship. And the lordship, I am saying it that on that date, 18/12/2025, the notice under section 40 was called by the Honorable High Court, your lordship. That after then 345 that is has been taken, but no any notice has been produced by the APP that it is received by the family members of the accused. So it is not the amount of the section 48, your lordship. Order dated 18/12/2025 of the para 6. In this record, your lord. I have no proof that family members of the accused has been received any notice that for what grounds that the accused persons are arrested, your lordship. And lordship, I have annexed the arrest memo, your lordship, of the page number page number 25 and 26, your lordship. In this case, your lordship, of the down, your lordship, witness name is Gopesh Thakuria and Trolikko Hawk. And in this case, your lordship, I could not find any signature, your lordship, of the accused person also, your lord, of the page number 25 annexure 4. And your lordship, the 36 of BNSS, your lordship. Section 36. Section 36 BNSS, your lordship. There have said that procedure of arrest and duties of officer making arrest. 36 clause B, prepare a memorandum of arrest which shall be arrested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made, and countersigned by the person arrested, and inform the person arrested unless the memorandum is arrested by a member of the family that he has a right to have a relative or a friend or any other person named by him to the inform of his arrest. And your lordship, there have mentioned the 36 para B clause 1, your lordship, that arrested by at least one witness who is the member of the family. Who is the member of the family? The person arrested or respectable member of the locality where the arrest is made. But your lordship, in this arrest memo, your lordship, I have annexure 4 court page number 25. We could not find any address of the witness, your lordship. We could not identify that the person is the family members or the locality of the arrested area, your lordship. And number 2, your lordship, there have been mentioned that clause 2, 36B clause 2, countersigned by the person arrested. There have no any countersign we have seen, your lordship. Page number 25, kindly go. Page number 25, memo of the arrest, I have arrest annex. And where is the 9.19 only grams of the recover, your lordship? But the accused number 2, who is the lady, your lordship? She is not the driver. She is not the owner of the vehicle where the articles recover, your lordship. And there have no proof that section 48 notice has been received by the family members, your lordship. Case diary is also received by the APP, could not produce, and it was called by the High Court on dated 18/12/2025 of the para 6. Your lordship, kindly bail may be allowed on the go merit, your lordship. Section 36 says, your lordship, I am not saying, law is saying, your lordship. Section 36 of the BNSS Act.
Yes, PP.
My lord, here, lordship, may kindly page the page 25, my lord. Here, although said that statement signature of the witness accused person is not here, my lord. Lordship, may kindly page 25, that is thumb impression, my lord. Why, my lord? And in page 26, it is the signature of the arrestee, Nawab Sharif, my lord. That is there, my lord. And there, contract
Your lordship, thumb impression, here have RTI, LTI, no any mention, your lordship. Thumb impression is not, I'm not saying that who has given the thumb impression, your lordship. They have mentioned that RTI of the Wahida, they have not mentioned. And she is the lady, your lordship, and she is suffering different kind of illness. I have also mentioned, submit the medical documents, your lordship, page number 43, your lordship. And they see, your lordship, kindly go to FIR also, see that the lady, she is not the owner and driver of the vehicle. This is the main fact, your lordship. And she is
Is the ground of her arrest?
No, lordship, 48 is not comply, your lordship, in this case.
I'm asking you, what is the ground of her arrest?
Ground of arrest is, your lordship, this is the commercial quantity, your lordship, 21C of NDPS Act.
Why was she, the lady, arrested? Was it found in her possession?
Fine.
No, lordship, she is not the driver. She is not the owner of the vehicle, your lordship. And the FIR is here, your
She was in the vehicle.
In the vehicle. Both of them, my lord.
But 48 is not comply, your lordship. 48 also
Don't
not
jump from
comply.
one issue to another. First, answer the queries of the court.
Yes, lordship, I am saying that of the FIR is page number 19. 19, page number 20, kindly go to page number 20 of the name of the address. This I also served the notice under section 50 NDPS ex suspected driver occupant, and they identified themselves as Nawaz Sharif, as 27 years, so and so, Wahida, and the second before the magistrate for conducting their personal search. The personal search, the suspected over the occupant, namely Nawaz Sharif and Wahida, was conducted in presence of SDPO. During their purposeful search, one Redmi mobile phone handset, and hearing your lordship, one original driving license, DL number so and so is the name of Nawaz Sharif. The registration certificate of the registration AA01AF 0549 in the name of Balinder Roy, and one PAN card and 5 PAN card number so and so in the name of the Nawaz Sharif. could not receive, and I'm not the driver, your lordship, so no any RC also is from me, from the Wahida also. And your lordship, where is the thumb impression? The learned friend has submit before this honorable court, but where is the thumb impression? There could not find. We have LTI or RTI that the name is mentioned. Who has given the thumb impression, your lordship? We could not identify it, your lordship. So where is the violation of 36 plus 1 plus 36 plus B plus 2 and 1 also is violation, because your lordship of the arrest memo, your lordship, the only simple witness name is here mentioned on the down part, Gopes Thakoria and Hawk, namely someone Hawk. And lordship, there could not mention any address also. So we could identify it that they are the person of the family members or locality. We could not identify, and they are not the family members of the locality of locality arrested. Where is they have arrested? They are the local person. We could not identify it, your lordship. So violation 36, B plus 1 and plus 2. 48 is not comply, your lordship. 48 is not comply. There have no proof that any message has been received, written grounds of arrest has been received by the family members of the accused, your lordship. There have no signature of the recipient. Yes, diary is also here. If APP has produced in here, then okay, your lordship, go to reject. If produce it, that the notice has 48 is received. Where is the she is not the driver owner. This is my additional grounds, your lordship. My main grounds is 48 is not compliant. And second, my ground is 36 plus B plus 1 plus 2 is not compliant. This is my two grounds, your lordship. So the accused person is right to go on bail on the merit, your lordship. Okay, then my friend is saying that Wahida has given the thumb impression, your lordship. But thumb impression, who has given the thumb impression, your lordship? Could not find it. Wahida, RTI, LTI. We could not.
It is a matter of trial, my lord.
No. This is. I'm not saying, your lordship. 36 plus 1 plus B.
Who has given?
Are 36 to sab na apuni. Apuni sab 36 to. BNS 36 kon sab. Sab. I'm not saying it, your lordship. Law is saying. This is not of my making sentence. Whereas the law is saying I am submitted here. Okay, lordship. Where is the commercial quantity, your lordship? There have one of the ruling, your lordship, where the violation of sex, is not comply under section 47 and 48, and then article 22 clause 1 is violation. Where is violation? The 22 clause 1 of Constitution of India, your lordship. Then 37 is not effect in this case, your lordship. I have a ruling, your lordship. May I allow for submit it? It is deduction by the. আৰু এটা আছে ৰ'ব ruling. Is that the question? BA number 1855/2025, decision is para number 16. Decision is para number 16, Your Lordship. In view of the entire facts and circumstances as discussed above, vis-a-vis non-mentioning of grounds of arrest in notice issued of the present accused petitioner, Section 48 BNSS, and non-compliance of Section 48 of BNSS, as well as the considering the view expressed by the Honorable Supreme Court in the case laws referred to herein above, this court finds it a fit case to extend the privilege of bail to the accused petitioner. This is the decision of paragraph number 16, BA number 1855. And Lordship, paragraph number 6. Paragraph number 6, Your Lordship. In the case of commercial quantity, the rigor of Section 37 NDPS Act follows, but in cases where there is a violation of the constitutional provision as mandated under Article 21 and 22 of the Constitution of India, the statutory restriction will not affect the power of the court to grant bail in such circumstances. More so, non-mentioning of grounds of arrest while issuing the arrest memo or notice under Section 47-48 of BNSS is itself in violation of Article 22, Clause 1 of the Constitution of India, and hence, without even going into the detail of the merit of the case, the present petitioner is entitled to go on bail. Section 37 is not effect in this case, because where is violation 22 Clause 1 of the Constitution? And Your Lordship, paragraph number 14. Where is the charge sheet submitted? Paragraph number 14. Paragraph number 14, kindly, Lordship. More so, the Honorable Supreme Court in the case of Bihan Kumar has also held that even after filing of the charge sheet, the arrest and the detention will be considered as unconstitutional, being violative of Article 21-22 Clause 1 of the Constitution of India. The Honorable Supreme Court in paragraph number 16 of the said judgment has held as under, Your Lordship, paragraph number 14, 16 of the Bihan Kumar judgment paragraph, an attempt was made by learned senior counsel appearing for first respondent to argue
Where
that...
have you stated about not taking your signature in the arrest memo?
Yes, Lordship.
Where have you stated that the thumb impression is not yours?
My lord. Averments in the petition whether you have.
Where is your averment that that is not your thumb impression? You have quoted the entire constitution. I am asking you about the facts.
Lordship, page number 25.
Your averment that it is not your thumb impression.
Lordship, there could not mention the thumb impression if we have taken the thumb
It is
thumb
stated
impression.
RTI of Wahida.
RTI is here, Your Lordship. But here could not find any that LTI or RTI. The thumb impression is here, but from whose person thumb impression taken? There could not mention. Where is LTI? Where is RTI?
Yeah, RTI is mentioned there.
Where?
It is RTI of Wahida.
My lord.
Lordship, I am saying that the witness.
RTM.
The witness also, Your Lordship. Actually, I could not see it. But identify it.
Why not? RTI. Wahida. RTI Wahida.
Okay, Lordship, but the witnesses where he's the taken the name, Gopesh Thakuria and the Kumbam Hawk or what it is identified, but here could not mention the address also. That how can we say that they are the person?
Where is the requirement in section 36 that the address must be mentioned?
No, no,
You are
Lordship.
relying on 36.
So the arrested, where they have arrested.
They may be
taken
respectable
the-
persons of the locality.
But Lordship, 48 also saying, Your Lordship. 48 also saying, Your Lordship.
Yes, we are coming one by one.
I have two grounds, Your Lordship.
Yes, 36 we have taken care of.
Okay, Lordship.
Now 48. You may have a valid ground on 48.
Yes,
You,
Lordship.
since you are taking all the grounds, we are coming one by one.
Okay, Lordship.
Yes, 48, what happened?
48, Your Lordship, 18/12/2025, the Honorable Court has called a 48 notice, Your Lordship. 18/12/2025. Kindly peruse the record. 18/12/2025. Paragraph number 6. Paragraph number 6.
6 of your petition.
Yes. No, no, not petition, Your Lordship. Order of this Honorable High Court. 18/12/2025. Order dated.
What order is there?
Record, Your Lordship.
Huh?
Record, Your Lordship.
In this case,
Yes, Lordship. 3301.
order dated
18/12/2025.
eighteen twelve.
18. Hold on. Eighteen 2025. Paragraph number 6.
Yes.
Notice was called.
Additional PP will address on this matter.
Yes, Lordship. Case diary also received, Your Lordship, now. So there have no proof that any notice under Section 48 has been received by the family members. And they are arrested on 18/8/2025. Still, no any notice has been received here. I have no any proof. Means, Your Lordship, no any written grounds of arrest has been received by the family members still.
What, whose signature is this receipt?
My lord.
The WT message.
My lord, WT message, my lord, fact is that the accused persons are from Manipur, my lord. They are from Manipur, my lord. Then WT message was sent to the concerned police station, my lord.
But the concerned police station also not said to us, Your Lordship, and we have not, the family members are not received it is. Law is saying that grounds of arrest must be.
Please sit. How I am talking.
Kindly go to merit, Your Lordship. Was the lady also here, Your Lordship? Is in Gifu court. And there have no any development treatment also, Your Lordship. Documents also are
Will examine.
My lord, here commercial quantity recovered from their possession, my lord, both, my lord, it is morphine, my lord. And lordship already find out, my lord, that 36 is complied, my lord, 47 also complied, my lord, 48 it is from Manipur, my lord, both of the accused person, my lord. It was sent through WT message, my lord, to the concerned police station or to send it to the family members, my lord. Here in the report, my lord.
But there have no any proof, your lordship, that the family members has received that grounds of arrest. So
But the
what
proof-
you say,
You are the proof.
may direct.
Contacted you.
No, lordship, law is not saying it, your lordship. That the law is not saying is here. Supreme Court also not saying is here, your lordship. That the Bihan Kumar judgment, your lordship. And your lordship, I have submitted the 2 rulings, your lordship. Paragraph number 6.
Yes, we'll take care of that. Yes, we'll see. We have not made up our mind. Consider.
No witnesses examined till today.
Witnesses examine, your lordship. I have. Do that. I have to collect the status report also.
Yeah.
I'm not going that grounds, your lordship. My simple grounds is where the 48 notice is not comply. 48 is not comply. My grounds, but. Yes, lordship. This is also same.
Other one.
Yes, lordship. Same grounds.
Same incident.
Same incident.
Not different incident, my lord, he is the driver and handyman, my lord. Okay. From their position, it was.
No, is it connected to this FIR?
No, lordship. This is the another FIR, your lordship. That is the July 44 and this is the July 47. Yes, lordship.
Here is also.
Same ground.
Same grounds, lordship. Lordship, in this case also, lordship, 11/12/2025, your lordship. 11/12/2025, kindly peruse the record of the High Court order dated 11/12/2025. Paragraph number 3. 48 was called for. That's,
Same WT message.
yes, lordship, same WP message, but could not receive by the family members, your lordship. They have no proof. They have no proof, your lordship. It was called by the High Court, Honorable High Court, 11/12/2025. After then, 3, 4, 5 decades has been taken, but no any notice has been.
So same ruling will be applicable.
Yes.
I can look at it.
Much obliged, lordship.
May I please, your lordship? In this case, the petitioner lordship, he was arrested on 8/8 lordship, 8/8/25, as on date 181 days in custody. And trial has already begun, lordship. And
Is the offense?
the facts, lordship, is that police from a reliable source, they searched the house of the accused and seized, lordship, 41.048 kg of Ganja, lordship. And as per the FIR, lordship, and the old that he was not at home at that time. He absconded as per the allegation, lordship. So subsequently, the seizure was made in presence of 3 seizure witness, lordship. Lordship has the seizure list. Lordship will find that 3 witnesses were in presence of 3 seizure witness. The seizure was made. Lordship, till on the earlier occasion when TCR was called for, lordship, at that time I think no witnesses were examined. But now, by now, lordship, 3 seizure witness already examined, lordship. So I would like to place this or on 2nd of this.
That is not available.
That is not available in the TCR. So, lordship, I have obtained a copy of all the 3 seizure witnesses. For the witnesses, lordship, So very short, Lordship, the seizure witnesses. First one is the Akbar Ali, Lordship. He state that I do not know the informant, I know the accused person. On 2/8/25 at about 7-8 p.m., police came to our house and took me to the house of the accused, Javed Ali, and told that they recovered ganja from his house. I saw one plastic packet in the courtyard of the police obtained my signature on a paper. Is the P1 so is the paper. Now I do not know where from police recovered plastic packet shown to me. Police did not show me the articles inside the plastic packet. I do not know who is the owner of the courtyard where I have seen the plastic packet. No inmates of the house were present when police took me to the courtyard of the house. I do not know the contents of so and so. Second witness also, Lordship.
There may be other witnesses.
Yes, three seizure witness, Lordship. All the three has been examined.
These other witnesses may not say, but
Minor, but
even the witness of the police is,
minor.
if it inspires confidence.
But these are independent witness, Lordship. Second one, Lordship, if Lordship will see, I do not know the informant, I know the accused person. On 2/10/25 came to Amtal Bangaligao and took me to the house of and show me a plastic packet and told me that they recovered ganja from the said house, but I do not know who was the owner of the house. Police obtained my signature, so and so. I do not know how many plastic packets were there. Police did not show me the articles kept inside the plastic packet. I do not know the contents of so and so. And the third seizure witness is also, I know the informant, I know the accused. He says that I know the informant also, Lordship. Dhiren Bhuya. On 2/8/25 at about 8:30 p.m., police told me to come to the house of accused. Police told me over phone, and accordingly I went to the house of accused and told me that they recovered ganja. I saw 7 numbers of polythene packets and police obtained my signature on paper. So and so, I did not see accused Javed at the place of occurrence. I do not know who is the owner of the house where I was called by the police. There are large gathering for persons along with police at that place of occurrence before I arrived. Police did not tell me where from they recovered the polythene packets and did not show me the articles kept inside the polythene packets. I do not know the content.
Yes, we have got your point. What we are on is that
Minor.
I think NCT versus Sunil, Supreme Court has already said that even if the independent witnesses do not support the case, if the police witnesses evidence are reliable, then that can also be acted upon. So at this stage, before they are examined, can we say that the bar of section 37 has been overcome?
Lordship, one thing is that, Lordship, independent witness has to support the seizure, Lordship, at least. And one more thing, Lordship. Now, I am not saying on the merit of the case, but whether my
You are submitting on the merit of the case.
further custodial interrogation will be necessary, Lordship.
That submission does not apply in NDPS commercial quantity cases in view of section 37. Third learned counsel for the petitioner, additional PP. This is an application under so and so. Paragraph 2. Bail petition. Learned counsel for the petitioner has submitted that the trial has already commenced and.
Lordship, one more submission before Lordship and see order.
Yes.
I just like to point out that, Lordship, I was not in the house and this is a case of plotting. I have made a specific statement in para 7, Lordship.
Yes, you have submitted that already.
Minor. And he is fled away from the house, minor.
No, Lordship.
That is there, minor.
Submitted that the trial has already commenced and 3 of the independent seizure witnesses have been examined. Learned counsel has placed before the court the copies of the depositions of the aforesaid 3 independent witnesses, wherefrom it appears that they have not supported the prosecution case. On the other hand, learned, it is also further submitted that the petitioner was not present in his house at the time of recovery. On the other hand, learned additional PP submits that there are other witnesses, including police witnesses, who will be able to prove the case against the petitioner, and that the apex court has held that the evidence of official witnesses, stroke police witnesses, cannot be discarded merely because they are police personnel, and their evidence can be relied upon if they inspire confidence. Para. It is further submitted by learned additional PP that the petitioner had fled from the house upon arrival of the police. Para, having perused the material on record and having regard to the aforesaid submissions, it cannot be said at this stage that there are reasonable grounds to believe that the petitioner is not guilty of the offense of possession of commercial quantity of ganja. Full stop. That being so, and in view of the provisions of section 37 of the NDPS Act, the prayer for bail stands rejected at this stage.
May it be please, my lordship. This is the search case, my lordship. In this case, the vital witness has already been cross-examined, and here the case is allegation of the section 6, my lordship. And in the cross-examination, in the witness, the petitioner has not been incriminated in this evidence, my lordship.
I have flag mark statement of the, my lord, victim 183 of the BNS, and
Is the evidence before the
Evidence-
court available?
Yeah, yes. Yes,
Where?
evidence is available. I have annexed in the petition, and maybe in LCR also may be available. This is the cross-exam, page number 45 in my petition. Cross-examination of victim. Sundar আছে 45 ভাল পাই problems.
The third learned counsel for the petitioner. Learned additional PP else. And copy of TCR has been received. The allegation against the petitioner as reflected in the FIR.
Yes, number 10 is the affair.
That he had taken away the victim who was aged about 17 years at that time to Delhi.
The NDPS case against him. The FIR is at page number 17, Your Lordship.
In this case, TCR has come, Lordship, but in TCR also I tried to find out the statement of the accused and co-accused if there is anything. But I have not found the statement of the co-accused persons. Lord.
Intermediate quantity, Your Lordship. 72 days behind bar date. I want to
Intermediate, let me see this.
The name of the present petitioner?
Mustaq Ahmed Laskar.
Mustaq Ahmed.
Yes, Laskar.
You were found on the spot.
No, Your Lordship. The vehicle from which the material was seized was left at some place. There was no one. Later on, I was shown as absconder. But how I am involved, that was not mentioned in the charge sheet. Your Lordship may turn to page number 27. Then paragraph number 17, Your Lordship. Facts disclosed during investigation. During the investigation, all possible legal steps were taken. So and so, line number 1, 2, 3, 4, 5, 6, 7, 8. Last part. During the course of investigation, the driver's name and address was collected, and the registration details of the seized MV was also collected from the DTO Kachar, which reveals that there are prima facie available against the accused Rahimuddin, which is the owner of the vehicle, so and so, and number 2, Mustaq Ahmed Laskar. But how I am involved, whether I was at that alleged time I was driving the vehicle or not, nothing was mentioned. And Your Lordship may see the FIR page 17, the first paragraph. I have the honor to report that today on so and so date at about 12 a.m. 20 a.m. on being received the information by OC so and so from patrolling staff by GD number 27 dated 01/03/25 of Dholai PS that one vehicle bearing no registration number was suspected, and when it was signaled by them to intercept or search, then the driver of the vehicle moved forward and stopped the vehicle by the edge of the road at Sodagram NS 306 and managed to flee away by leaving the vehicle, which made them to believe that there might be suspected attacker. Whether I was driving the vehicle or not, that was not mentioned in the charge sheet. And when notice was issued, I surrendered before the Honorable Learned Court below, and I was sent to judicial custody. The quantity is 183 grams, intermediate quantity, which is at page number 21, seizure list. 183 grams.
Who is the owner?
Yes, Lordship. Owner is the first accused Rahimuddin Laskar. Rahimuddin. Charge sheeted accused number 1, Rahimuddin Laskar. He is the owner of the vehicle. That is page number 25. Particulars of the accused, serial number 10. 1. Mustaq number 2. Absconder देखा है इसलिए episode के charge sheet for episode 30. No, he signed a course code.
Charge sheet, this Mustaq Ahmed and Rahimuddin, they have not been shown as absconder. In charge sheet, Lordship, they have not been shown as absconder. Lordship. Page 25, Lordship. Particular to the person.
But he surrendered before the court
Yes.
after filing of charge sheet.
Yes, sir.
Huh?
No,
He was not arrested also.
The charge sheet was filed on Lordship
27, 12, 21.
Charge from 34, 25.
Yeah.
Our secretary associate.
He arrested us around 25, 11, 25.
Then Lordship.
So he is the alleged driver.
Yeah, he is alleged, but
No, it's charge sheet says that the driver's details were collected.
That
What detail is collected?
he was driving at that alleged time.
Any appointment letter?
No.
I also tried to find out the link, Lordship, but I could not find it.
It had learned counsel for petitioner. Learned additional PP. This is an application under so and so. Can you go to page 29, huh? Brief facts of the case. Where it appears that the petitioner had surrendered before the learned court below, whereafter he was remanded to custody on
25, 11, 25.
24. It's a perusal of the FIR as well as the charge sheet. Would reveal that the present petitioner, Mustaq Ahmed Loskor, has been implicated as being the driver of the said vehicle, which was found in an abandoned condition. It is submitted that there is no material to show that the petitioner was driving the said vehicle on that day. Also, although the IO has stated in the charge sheet that the driver's details has been collected during investigation, no such material could be pointed out from the record. There does not appear to be any other material connecting the present petitioner with the recovery of the contraband from the abandoned vehicle. Having regard to the same, this court is of the view that there are reasonable grounds to believe that this is not commercial quantity.
No, intermediate.
In regard to the aforesaid facts, cut that line. Having regard to the aforesaid facts as well as the period of detention of how many?
72 days.
Huh?
Today, 72 days.
72 days. The prayer for bail is allowed. The petition so and so shall be 50,000 to say it is further provided that the petitioner shall regularly participate in the trial and shall not tamper with the evidence. That is the chamber of the Filway bail. So
May I please, Your Lordship? For its application, Your Lordship. Today around 61 days, Your Lordship. 10.02 grams of heroin was seized from 2 persons, Your Lordship.
how much?
0.02 grams, Your Lordship. Heroin.
Intermediate.
Intermediate, from 2 persons, Your Lordship.
Charge sheet submitted, my.
May consider, Your Lordship, 61 days as of today.
There is sufficient material against you.
Nothing was seized from the petition number 1. He had visited the place of petition.
Who is petitioner? Unmun.
One, Your Lordship.
Unmun Tati.
Yes, Your Lordship.
There are two petitioners.
He is the son-in-law actually of petitioner number.
Huh?
He is the son-in-law of petitioner number 2. He has visited their place on that day.
Was it recovered in body search?
Yes, ma'am.
Body search.
Search their body after observing the plane. Found no, my lord, nothing found from their body, ma'am. Nothing found from their body. After that,
Where are you reading?
Page 18, my lord. Page 18, my lord, last portion, my lord. On being found, the suspected person, namely Sri Munmun Tati alias Gopal, son of Badal Tati, so and so, and Ramesh Basfor, son of late so and so. The inquiry officer, SI so and so, searched their body after observing the formalities of NDPS Act in presence of independent witnesses and found nothing from their body.
Only on house search of the petitioner number 2.
Yes.
One is not a resident of that house. His address is different.
He is the son-in-law of petitioner number 2.
Maybe son-in-law. But if it is not his house, can you say it's the recovery?
One may be considered regarding
Third learned counsel for the petitioner. Application. So and so. Page 18, okay, annexure to brief facts of the case. It appears that the petitioner number 1 is the son-in-law of the petitioner number 2. Was found in the house of the petitioner number 2. When the search was made, it appears that nothing was recovered from the body search of the petitioners. The recovery was made from the house of the petitioner number 2. It also appears from the record that the petitioner number 1 is a resident of this. appears that the petitioner number 1 resides separately from the petitioner number. Therefore, prima facie, it appears that recovery was not made from the petitioner number 1 at that of the petitioner number 2. Having regard to the above, one is allowed. Prayer in respect of petitioner number 2 rejected at this stage. Accordingly, it is directed that the petition number 1, Sati alias Gopal, shall be released on bail of rupees 50,000 with securities of like amount. The conditions, you know. Yes.
Obligation.
5th March.
May it please your lordship. 483 bail application, your lordship. FIR is at page number 16, your lordship. Read the FIR, your lordship. Page number 16.
Yes.
Respected sir, this is to inform you that on 7th of December 2025 at around 2:36 p.m. a Naka checking was conducted at NH27 Udali near Udali PP. During Naka checking, an information was received from reliable source that a truck bearing registration number AS 260381 is carrying illegal drugs from Kachar district. Later, the vehicle was found at Naka checking and taken to Udali PP campus. Information was sent to Osilonka PS and Osilonka has sent me an authorization letter. Later, the truck was searched in presence of 3 independent witnesses, 1, 2, and 3. Thereafter, Lordship, during search, the following articles were recovered from two accused persons, namely 1, Ziabur Rahman Chaudhry, 26 years, son of So, and Akhtar Hussain Lashkar, son of this, were apprehended. The below named recovered articles were seized. 9 packets of suspected heroin, your lordship, with total weight around 270 grams, your lordship. Here, your lordship, we are for both the petitioners. One was the driver and one was the helper of the truck, your lordship. And the truck was loaded with betel nuts, and within this betel nuts, somewhere either the loader or the owner had hidden some drugs, your lordship. This is our contention with regards to the facts of the case, your lordship. Furthermore, your lordship, during the process of arrest, your lordship may kindly come to page number 6, your lordship. Sorry, page number 28, your lordship, annexure 7. Page number 28, annexure 7, your lordship. This is with regards to the section 47 notice, which was given to the accused person. Page number 28, annexure 7, your lordship. And this notice is up to the mark as per the guidelines laid down in Prabir Prokast and Vihan Kumar, your lordship. We do not have a problem with annexure number 7, page number 28 and 29. Thereafter, your lordship, in page number 30 and 31, your lordship, this is the section 48 notice which was served to the relative, that is the mother of the accused person number 2, and another accused person. The same section 48 notice in both the cases does not include any specific grounds of arrest for which they have been apprehended, your lordship, thereby creating a direct implication that the procedural safeguards which have been mentioned in this particular memos has not been fulfilled, your lordship. That is our second contention with regards to the case. Furthermore, your lordship, 59 days behind the bars, and the quantity is 251 grams with the packets, your lordship, which very probably with FSL will come down below 250 grams, your lordship. That would be intermediate quantity, your lordship. These are 3 grounds with regards to the entire case, your lordship. Insufficient 48 notice, the primary ground, your lordship.
$51 or 270 grams?
270 grams.
270 grams, including the entire weight, your lordship. And in the seizure, your lordship, in page number 41 and 40 and 40, page number 39 and page number 40, your lordship will see which we have mentioned in our averments, that without the foam, it is mentioned in the inventory when the sampling was done, that without the foam, a foam was attached in all this container when it was completely measured. A different kind of foam which is not in contraband, your lordship, and the total weight comes down to, your lordship, 251 grams, which is mentioned in the sampling order, your lordship.
It is also commercial quantity.
Paragraph number 8, your lordship. By 1 gram, it is commercial quantity without the FSL, your lordship. And our primary ground is with regards to 48 being insufficient, your lordship. It is apparent from the record of the case, your lordship.
Your lordship, I point out, my lord. One note in the section 48 notice last portion, my lord, SI Dilip Kumar Borua, IO of the case, explained the accused persons about ground of arrest in their own language.
Exactly, your lordship.
It is
should
accused
have-
persons.
It should have been to the relative or the mother of the accused person who is an illiterate
It is
person.
section 48, my lord.
She has given her thumb impression, your lordship. Clearly illiterate person, your lordship.
Lordship. It is last portion of the section 48 notice, my lord. And your lordship may kindly peruse one order of the trial court, my lord. The order of the trial court star mark, my lord, flag mark, that order. Next, my lord, next, that is star mark flag.
Sometimes it so happens that the second page where the grounds are there,
Yes, my lord,
it
that is.
put somewhere else.
But your lordship may kindly peruse the order of the trial court, that will, my lord, speak everything.
Our case is not with regards to section 47. 47 has been complied. A similar notice should have been on section 48. That is our
48
case, your
also,
lordship.
those accused persons were asked regarding the, my lord, serving of notice and grounds of arrest to the relative. They, my lord, in fact, stated before the trial court that they.
Your lordship, that primarily does not indicate that we have been
It says,
served.
yeah, notice has been given, so they are aware of the arrest. But what about grounds of arrest?
Then I will have to get the, because the note in the forwarding report 48 last portion, a note is there that, my lord, Dilip Kumar Borua has informed about the grounds of arrest in their own land. Whether
The accused only.
if, my lord, that part is missing, then also I will have to get verbal instruction.
Only to the accused person. Thereafter, there is a
After
signature.
stating that, my lord, at this point of time, otherwise, my lord.
This prima facie is an illegal detention, your lordship. However, your lordship, accused number 2 is just 19 years old, your lordship. 27A is also not attracted in this case, your lordship.
Section 47, detailed grounds of arrest is there, but in 48, my lord.
And you, where will you get the instruction beyond the CD?
The difficulty. Because after some time, I will again look, my lord, if.
You want to see the CD again?
That if that portion is there in the CD, my lord, maybe.
All right, after some time.
Deeply obliged.
May I please? As on date, Lordship, 28 days behind bars. As per the FIR, Lordship, which is at page 9. Moto FIR been lodged by the SI of Nunmati PS. Lordship, on so and so, at about so and so time, information was issued from reliable source over phone that 3 vehicles, namely one auto rickshaw, one so and so, so and so, so and so. Accordingly, the same said information was immediately shared with the DCP and search was conducted. During the operation, one auto rickshaw bearing so and so, this is the auto rickshaw which I was driving. It is a passenger auto. Allegations are that I was carrying 5 numbers of jar which are containing petroleum products. The jar, lots of drums basically. Lordship, in a passenger auto, 5 numbers of drums is a matter of suspicion, Lordship. Lordship, another aspect I want to bring to your notice is that
One is a mini truck.
no, Lordship, other vehicles are there. Those vehicles are of other persons. I am the owner. I am the driver of the auto rickshaw, passenger rickshaw. The contradiction, Lordship, I want to bring to your notice is that the place of conducting the seizure is different from the first contact. I was pressed by the police officials in an area, open area at Modgoria, and the seizure was made at nearby the IOCL. Lordship, there is a contradiction. Lordship, another aspect, Lordship. Another aspect, Lordship, I want to bring to your notice is that, Lordship, I have on oath stated that I don't have any prior communication with the other vehicle holders. On oath, I have stated I have no communication, no phone history is there, Lordship. And I was loitering nearby. I was not in the auto rickshaw also. It was a cold day and I was sitting behind a fire pit, Lordship. My involvement is not at all there, Lordship. And already 28 days and similar matter, Lordship, I am relying in a order of our own High Court, 29 days, similar sections, 305C and 7 of ECA. And Lordship, sections as per so far section 7, that is purely available and very much good interpretation of this, our own division bench is there that I am placing.
Section 7 of the Essential Commodities Act is available, but regarding
Purely
the
available.
other offences, because that is only because those vehicles were stolen from the that is the from the parking area of the IOCL, from those trucks which were parked there, those are the tankers of the IOCL, and from that is a organized racket is involved in committing this type of offence, and the present accused person was caught red-handed. Thereafter, the other 2 vehicles which were later on, apprehended by police, the drivers of those,
Led by him.
were, yes.
Lordship, similar pattern, 29 days, other accused. I may be given same liberty, Lordship. Lordship, as per the bail rejection order of the learned court below, witnesses are also done, all the goods are also seized, then what remains? The case is charged sheeted, I am ready to face that file. My mother is staying with me, Lordship. No one is there to look up to my mother. I mentioned in my para number 11 of the petition, Lordship. My mother, who is a widow and old lady, I'm only the one to look after her. I have no history, no antecedent of Any criminal nature?
Hard learned counsel for the petitioner, learned an application under so and so. The FIR upon receipt of prior information, Nunmati police conducted search operation around area and intercepted the photo of the petitioner wearing registration number AS01 E01 from 5 plastic drums filled with suspected diesel were recovered. Subsequently, 36 plastic drums were recovered from 2 other vehicles which were found in abandoned condition. Is the submission of learned counsel for the young person is it 19 years and has no antecedents, and the articles have also been recovered. In regard to the period of detention of 28 days, the petitioner may be released on bail, especially since he has to look after his mother, who is all alone. Further submitted that under similar circumstances involving theft of petrol, oil, okay. Accused therein was granted bail after the High Court. Bail application number 3722 2025 512 5, copy of which has been court. Having regard to the above, for bail is allowed, the petitioner is on bail of rupees. Right, two securities of like a not the learned. Cooperate with the investigation and the evidence, try to influence any witnesses connected.
I'm a brother.
He was here.
Please. This is page 9 is the FIR, Your Lordship.
Petitioner is Your Lordship, Your Lordship, Afroza Khatun, he is behind the bar for 136 days. Case 9 is the FIR.
It's submitted.
That's it, submitted, sir. Submitted on 26/11/2025. One Moinul Haq committed the offense here. After that, on the basis of statement of Moinul Haq, if Your Lordship gone through the statement of Moinul Haq, is I found Your Lordship page 49 of the TCR, that Lordship will be clear what is done. The reference petitioner's name is
This is on behalf of Afroza Khatun.
Lordship. He's behind the bar for 136 days. 136 days behind the bar, Your Lordship. He's a married lady, Your Lordship, having 3 minor children. Gone to the statement in the TCR of the
TCR?
Moinul Haq. 49, I have found the statement of crime accused Moinul Haq. 49, Your Lordship. Of the record.
This is blackmailing.
Blackmailing, my lord. And from the statement of the other witnesses also, it reveals that at that time of 10 to 11:30, my lord, they have seen both of them talking with it. And in the statement of the accused person, it all reveals that she was at the present at the spot, my lord, where the incident happened, my lord. PM report also shows my several injuries, my lord. And here, lordship, evidence is fixed on, my lord, 4/2/2026, my lord. This is not yet examined, my lord. My humble submission is that, my lord, some of the material may be examined, my lord. After that, bail petition may be considered, my lord. It is a
36
heinous offense, my lord. 103 is there, my lord. From our statement, from the statement of the accused person and other also, my lord, it reveals that both of them are, my lord, there at the place of occurrence, my lord.
Prime because Moinul Haq is stated only to take revenge, only to some take revenge. The petitioner is falsely implicated.
It cannot be said as listed.
Statement clearly said that petitioner has not implicated. Said by the Moinul Haq.
Where along with, you are there along with him, you went to the place of occurrence, you assisted him.
My lord.
How can you say
Okay,
there is no
but
material?
there is some relation, is there is controversy is there. Because that estimated relation
Some
that
photographs are there, my lord, how brutally assaulted, my lord, photographs, my lord.
136 is a local lady and having 3 minor children. No chance actually because statement of the prime accused is that question that petitioner has insulted here. Self-stated that he alone has committed the offense. But he is
No,
stated
that
that
statement
petitioner
not
is
there, my
present.
lord. He never said, my lord, he is not assaulted, my lord, but he said that he, perhaps he or she also assaulted, my lord, when he senseless, my lord. That statement are also there.
Also implicated because there is some relation is there, I has statement there, because therefore she is implicated the petitioner. Petitioner is
My
not
submission is that some witnesses may be examined, my lord, after that it may be considered. That is very
36
serious and
days.
heinous offense.
Having 3 minor
Not learned
children.
counsel for the petitioner, not additional PP application under so and so. As per the allegations contained in the FIR, the deceased person was called out that night by the main accused to go for fishing. Thereafter, the deceased was killed with the assistance of the present petitioner, with whom the main accused was in a relationship. It appears from the statements of that the deceased had been blackmailing the petitioner and the main accused with regard to their relationship. The material available in the CD clearly implicates the present petitioner as well. Is submitted by learned counsel for the petitioner that there is a lady having children who have to be looked after and has spent around how many days?
136 days.
6 days behind bars. It is the submission of learned additional PP that in view of the incriminating material available against the petitioner, the prayer for bail may not be considered till some of the vital witnesses have been examined. Regard to the above, the prayer for bail is, and the gravity of the offense, the prayer for bail is rejected at this stage.
Bless.
Yeah, please, your lordship. 46 is 483 BNSS application, your lordship. Allegation brief in the FIR is at case number 11, your lordship. Lordship may kindly look in the case number 11, your lordship. The allegation is that one SI of Arumtul PS, your lordship, intercepted one vehicle, your lordship, loaded with 18 numbers of buffalo, your lordship, and arrested, your lordship, 3 of the petitioner, your lordship, before this honorable court, your lordship. And as of now, your lordship, 50 days behind the bar, your lordship. And the case registered, your lordship, under section 3032 of the BNS, 13(1) of the Assam Cattle Preservation Act, and 11(1) A and B of the Prevention of Cruelty to Animals Act, your lordship. Your lordship, the buffalo, your lordship, has been genuinely purchased, your lordship, by petitioner number 1 of item number 48, your lordship, 47, your lordship. That I have annexed with this petition, your lordship, from page number 20 to page 31, your lordship.
$51.
50 days as of now, your lordship. From 18 December, they've been arrested, your lordship. 50 days behind the bar, your lordship. And one more thing is there, your lordship. As 13(1) has been added, your lordship. 13(1) of the Assam Cattle Preservation Act has been added in this case, your lordship. If your lordship kindly see section 13 of the Assam Cattle Preservation Act, your lordship, to attract that section, your lordship, section 4, 5, 6, 7, and 8 of the that act have to be validated, your lordship. And section 4, 5, 6, 7, and 8 speaks about slaughtering of cattle, your lordship. But the FIR, your lordship, doesn't speak about slaughtering of cattle, your lordship. It is saying about the smuggling of cattle, and it is alleged to be stolen, your lordship. But your lordship, it have been stolen, your lordship, genuinely purchased from one Rangulu market, your lordship, that I have annexed, your lordship, all the receipt, your lordship. And these are the lordship driver and handymans of the vehicle. The FIR itself speaks, your lordship, regarding the same, your lordship, that they are the helper and the driver of that vehicle only, your lordship.
Yes, PP.
Pilot here, item.
46,
Yeah.
46.
No. Item- Well, they driver and handyman, my lord, there. Mustang Ahmed and 46, my lord. They
Yeah.
are the driver and handyman, my lord. At that time of when police apprehended the vehicle, they failed to produce any documents, my lord. From their statement, it reveals that as per instruction of their owner, my lord, they have carried the cattle, and they also know that it will be transferred to the my lord from my lord. Bangladesh mailer. It will be transferred to the Bangladesh mailer. And from it also reveals that from the case mailer, it was 18 numbers of mailer buffalo was taken in a vehicle mailer and in this mailer, one already died mailer. How they have cruel manner mailer they have transported the vehicle without having any medical documents transportation permit mailer. They have transported the buffalo mailer. And in this process, one already died, my lord. And they have failed to produce any documents, my lord, at the time of my lord. Asked about the my lord documents, my valid documents, my lord. The driver and handyman from this it reveals that they are suspicious about that it was my lord stolen, my lord. And
What is anything about this genuine purchase they have?
no, my lord, no, my lord. Here, although my lord, in the item number, my lord, next item, my lord, AB, my lord, interim granted, my lord. They have claimed to be the owner of the my lord.
That same incident.
My lord, same incident, my lord.
Incident, your
They are the
lordship.
owners, claim to be the owners, but they have not. They are interim granted, my lord, but they have not appeared before I, my lord.
They
Till
have
date,
not appeared.
Not from our record, my lord.
But as
Uh,
per
his
my
statement is
knowledge, your
not-
lordship, as per my instruction, your lordship, they have appeared before the IO, your lordship, after getting the interim, your lordship.
When appeared here.
On 21 only, they got the protection of privilege of PRS bail, your lordship, 21/1/2026, your lordship. But after that, your lordship, as per my instruction, client instruction, your lordship. they
CD is up
appeared
till
in-
when?
My lord, I am, yes. CD on 21/1, my lord.
So
On that day perhaps it is.
Lordship, my humble prayer, your lordship, at item number 46, your lordship, as of 50 days behind the bar, your lordship, he may be released on bail, your lordship, with due respect, your lordship.
heard learned counsel for the petitioner and met additional PP decision application under so and so. The allegation against the present petitioners are that they are the driver and handyman of the vehicle which was intercepted by the police, and 17 numbers of buffaloes,
18 numbers.
18 numbers of buffaloes were recovered therefrom, one of which was already dead. The petitioners were arrested on when?
18 December, your lordship,
18 December 26, 25.
25.
Have by now spent 50 days behind custody. There are having regard to the nature of the allegation and the period of detention, the prayer for bail is allowed. 50,000 to securities.
47 interim will be
Condition delivered. 47.
My lord, 47.
Your lordship. They are the owner of those cattle, your lordship, and petitioner number 2 is the owner of that vehicle, your lordship.
So they have said that they have purchased it from the bazaar, my lord, but they have not put.
We need to see their
My lord,
statements.
My lord, up to date, my lord,
Lordship.
for verification of the. They produce, my lord, up to date.
Continue, your lordship.
At learned counsel for the petitioner, learned additional PP, it is submitted that pursuant to interim order granted by this court, the petitioners have appeared before the IO. But the CD is, it is submitted by learned additional PP that the CD is not up to date. Hence, call for the up to date CD. List again on so and so interim order passed earlier to continue
of
till the
March.
next date of listing.
5th of March.
Made, please, your lordship. Lordship, this is an 483 application. The FIR is on page number 14, lordship. May I read, lordship?
Page
14, lordship. May I read, lordship? That,
yes.
That on 26/1/26 at about 11 a.m. Reliable information was received that migratory birds were being illegally poisoned and killed at the backside of the paddy field of the Komargaon village. That immediately after the receipt of the information, I along with my staff rushed to the place of occurrence. On the reaching of the spot, it was observed that many migratory birds were found in poor and abnormal conditions, showing the sign of poisoning. Further, 3 migratory birds were found dead at the spot, and many numbers of birds were found injured due to poisoning. And that the said 3 dead birds and injured ones were handed over to the forest department officials further examination and necessary legal procedure. During the preliminary inquiry at the spot, it come to the light that some persons had deliberately used furadhan, a chemical poisonous substance, in the said paddy field to kill the migratory birds with the intention of causing the meat of consumption and for selling. The subsequently during the inspection of the said paddy field, crashes of several migratory birds were lying scattered in the field, which clearly indicated death due to the poisoning. The feathers were also found the surrounding area, further confirming the occurrence of mass killing after the handing of the injured migratory birds. The dead ones, I returned back to the Bongaon OPD. And again at about 1:50 p.m., reliable and credible information was received and the from the local sources, and some of the persons of the Komargaon village had intentionally used Puradhan chemicals, which was used as a insecticide and for saving the crops, lordship, from the insect. And in the paddy fields located at the backside of the Komargaon village, which pre-planned intention to kill the migratory birds which regularly visit in the said area during the winter season in Majuli. Lordship, and if you peruse the page number 15, that during the careful second paragraph, during the careful search of the said camp house, the following incriminating articles were recovered and seized in presence of the available witnesses: on one plastic packets inside the Furadhan and furthers of migratory birds, lordship. The recovery of the above articles clearly established that the below noted accused persons were engaged in illegally killing of grailer goose and possession of migratory birds, and that the birds were intended for consumption of meat as well as for selling the financial gain. The acts that acts of accused of the persons amount to the heinous and offences under the provisions of Wildlife Protection Act 1972, lordship. Then on the basis of this FIR, lordship, Jengrai WL 7 of 2025-26 case number under section of 9, 44, 50 and 52, read with the section 216, and under section 51 of the Wildlife Protection Act was a case was registered by the Forest Department. Lordship, in this matter, I would draw your lordship's attention so that they were searching at the morning of the morning and on that particular day at about 11 a.m. and they were found some migratory birds and three dead body of the birds. But after again at 1:50 p.m. when one of the police personnel, according to the factual metrics, that one police personnel informed one of the applicant before your lordship that the police wants to come again and search the place, and you and other two applicants came and to cooperate with the police personnel. And the applicants before your lordships, they were Bikhoya, that is called the manages the bill, which was called as a Noido bill. I have a statement made in the paragraph number 2 of my bail application, lordship, under the supervision of one Paresh Soikia, who took the lease on the bill. So they cooperate with the police personnel, and suddenly additional superintendent of police came and detained all the persons present there. Almost 17 persons were detained on the 26th day of January, and thereafter they were shown arrested on 27th, and they are produced before the magistrate on 28th of this January. Lordship. Lordship, in this matter, lordship, in FIR they encloses the seizure list, but the seizure list was later seen by the learned chief judicial magistrate. The FIR, if you lordship seen that page number 18, it was seen on 28/1/26, but in lordship FIR seizure list, it is on page number 19. The scene was 2/2/2026, lordship. It was later. The seizure list was produced later before the learned judicial magistrate. The top of that page.
It will continue.
this regard, the FIR was lodged against that applicant before your lordships. The applicant was not connected with the alleged offense. But the punishable is the section which is section 51, which is punishable. Punishment is less than 3 years. 3 years up to the 3 years.
Yes.
Case diary may be called for, matter may be fixed next week. I'll try to.
This is for motion.
Motion, lordship.
How many days in custody now?
From 20, it was shown as arrest on 27th January. But if today is the
27
9th.
January. Learned counsel for the petitioner.
Lordship, one more prayer, Lordship. Lordship, in this bail application, there was a inadvertent mistake that Lordship, that in the clause title, the printing was left out. The section 52 is missed out. So may I permitted to put the section 52 in this bail application?
All right. So heard Mr. So-and-so learned counsel appearing for Forest Department. Just prayed for by learned. What do you call CD or your
Case diary, madam.
case diary? Give it earlier, I think.
12 or 16. Lordship. 12. Lordship. 12. Deeply please.
All right.
Please, your lordship.
25, my lord, regarding that 48 notice, I have checked, and in arrest memo, grounds of arrest is there, my lord, in 47, grounds of arrest is there. 48 also notice is there, my lord, at the last portion of that notice, my lord, that only one note is that grounds of arrest was explained by the IO of the case, my lord. That is, and thereafter, my lord, one order also I have found passed by the trial court that the accused persons on being asked.
No, we were on 48, I think, huh?
We are on 48 in the lordship.
Yes, what have you found in 48?
My lord, 48, my lord, here, 47, for my lord, arrest memo everywhere, grounds of arrest is there, my lord. 47, 48 also, my lord, notice is there, my lord. But there, my lord, there is, my lord, specific written grounds of arrest is not there, but one, my lord, note is there that grounds of arrest were explained to the accused person, my lord.
How can it be?
And
Requirement
here I
is
have-
of writing.
And moreover, to the person to whom it is served, your lordship.
Yes.
48 is not for the accused, and in 48, note is about the accused and not about the relative of the accused, your lordship.
And my lord, one order of the trial court is also there, my lord, I would like to point out, the accused persons on being asked.
No good.
Stated to be aware of the grounds of the arrest.
That's no good. That's been said in.
Yes, that is not there in 48, my lord. Otherwise, my lord, how he is prejudiced, my lord, that also one of the bad at that point of time, he is not.
At that time, to take the plea itself, we would require the ground of arrest. That is a humble submission, your lordship. Age is 19 years of petitioner number 2, your lordship, and both are neither the custodian of the traffic nor the custodian of the goods which are being carried, your lordship. And it became commercial quantity by only 1 gram, your lordship. Already 59 days behind this bar, your lordship. To be considered at least.
But heard learned counsel for the petitioner. LPP, this is an application under so. In brief facts of the case, is 19 and 20. Learned for the petitioner has assailed the arrest primarily on ground of compliance with the provisions of section 8 NSS relating to service of written grounds of arrest upon the relatives stroke friend stroke nominated person of the arrestee in violation of the directions of the apex court in Bihan Kumar versus State of Haryana. It's under section 48 NSS was to address to the mother
Mother of petitioner number 2 and uncle of petitioner number 1, Your Lordship.
the mother of the petitioner number 2 and the uncle of the petitioner number 1, which are annexed to the instant bail application. The same are also available in the CD. On perusal of the same, it is found that although the notice was issued, no grounds of arrest have been mentioned therein. LPP submits that the remand order passed by the magistrate has been observed that the accused persons have stated
Yes, ma'am.
that the
The
family
accused persons on being asked stated to be aware of the grounds of their arrest and that their families were also aware of their arrest and they have no injury nor
that
or
the accused persons have stated that their family members are aware of their arrest. However, they did not state that the grounds of their arrest have also been made known to their family members in writing or otherwise. Having regard to the above, the prayer for in regard to the above, it is evident that the arrest has been rendered illegal on account of violation of Section 48 BNSS and the directions of the apex court in Bihan Kumar Supra. Consequently, the prayer for bail is allowed based on bail of rupees so and so 50,000 and 1 lakh each with 2 sureties each of like amount. The satisfaction of the TJM हो जाए.
NDPS should be sessions हो जाएगा.
Huh?
NDPS sessions हो जाए, Your Lordship.
Special judge
Settled
NDPS
judge
Hosai is further provided that it would be open for the IO to proceed as per the procedure laid down in here. Sir versus will give the citation. Yes, the custody of the petitioners are found to be necessary. Petition stands disposed of accordingly.
Deeply obliged.
Let me, Lordship. CID is number 15. Lordship, nothing was seized from me, Lordship. So I applied for the recruitment process. I don't have any certification, nothing was recovered from me. I appeared before the CID. My statements have been recorded, Lordship.
So you have managed without the order of the court.
Lordship, everybody is appearing, but nobody is arrested.
Huh? This is
Nobody
AB.
arrested. Yes, Lordship.
So you have no apprehension now. You appeared, you were not arrested. What is your apprehension?
Earlier, I filed it earlier, but later on I appeared when
You are not granted interim.
not Lordship.
Actually, some of the persons were granted interim in some other cases, my lord. Those in some of the later on, my lord, in some of the cases, bail of those petitioners are receipt of this case diary, my lord. Case of some of the petitioners probably
Rejected.
rejected. Your Lordship, may kindly peruse para 6 and 7 of the present petition of the petitioner. Page 4, para 6.
Oh, this Techno Global, Madhya Pradesh.
In fact, admitted that, and he stated that he inadvertently, my lord, uploaded that, my lord, educational qualification document, my lord, the website. And later on, and now, your Lordship, may kindly peruse paragraph 7 and 8, my lord. Well, my lord, recruitment process was going on for selection of graduate and postgraduate teachers, my lord. They have, my lord, submitted fake educational qualification document. First group of persons by paying some money, they procured those. Larger group, my
Do you have any earlier order passed by us?
regarding those cases right now.
All the bail application were rejected earlier, Lordship.
The case numbers are there. We will see.
My lord, from that university, from Techno Global University, my lord, district Birsa, Madhya Pradesh. Also, my lord, those certificates were, my lord, sent for verification. Their report is also there in the case there. Voluminous case there, my lord. Regarding the present petitioner, he in fact, my lord, admitted in paragraph 7 and 8, my lord, that he stated that due to near.
But no documents have been seized from me, and I appeared in the statements have been recorded, Lordship. So further custody interaction is not necessary, Lordship.
So any record of their statement?
Regarding statement, I will.
Yeah.
29 and 30 my lord charge sheet submitted in this.
May I pray one thing, madam? The Lordship may protect us from some days, madam, we'll appear, madam, we'll apply for regular bail, madam.
We've heard Mr. Learned Counsel for the petitioner. Petitioner PP submits that charge sheet has been submitted by CS number.
Which number?
CS number my lord 281/25 dated 30/12/25.
That counsel for the petitioner submits that the petitioner shall appear before the learned court below and apply for regular bail. Accordingly, the present application is disposed of with the observation that the petitioners may approach the learned court below. And in the event of their filings, any application for bail, the same shall be considered per law. It further directed that the petitioner shall appear before the learned court below within a period of 15 days from today. Until then, the petitioners of their arrest released on interim bail of rupees 50,000 with one surety each to the satisfaction of the arresting authority.
Like your lord.
It is disposed of.
Right, your lordship. This is a POXO case, my lord.
Service not yet completed.
Service is awaited, my lord.
This is POXO.
Charge sheeted case my lord, scan copy of TCR not received.
I think it is received. Service was on.
Get the instruction my lord regarding service. Any short date may be fixed, I will get the instruction. My lord.
Learned Counsel for the here is scan copy of TCR has been received. Service on response still awaited. The matter again on
22.
In the meantime, learned any instructions regarding the concerned PS. Keep your
Be not received my lord. Instruction regarding service of notice also.
submits that CD has ordered respondent number 2 matter on again on.
Sorry.
May please, your lordship, it's wrongly.
Well, actually, this matter earlier listed, initially listed for motion on 19/1/26. On that day, matter was adjourned, so no order yet passed, my lord. So this matter may come up for motion, my lord.
Motion.
Section was already there. This for motion. Just a moment.
On 19/1/26.
Associated case.
Can copy of this here, maybe.
As per order dated 29/1/26, the matter was to be listed in the motion column today, but it has come up for bail hearing. List the matter again on. So in the meantime, call for the scanned copy of the PCR in with charge sheet number 608 dated 20/12/23.
Please, your lordship. And FIR page number 10, man. Offense under section 109, my lord. Raising on the issue of battle nut, my lord, two parties have been altercation have been taken place, and ultimately some assault has been taken place. And simple injuries has been sustained also both the parties, my lord. I have also sustained injuries, my lord. Simple injuries, my lord. Page number 14, my lord. And we have also filed one case, my lord. Our case has been withdrawn, my lord. So the page number 15, my lord. Amicably settled, my lord, between the parties, my lord. And after my withdrawal, my lord, after 7-8 days, my lord, the informant filed the instant case, my lord.
After compromise.
After the compromise, my lord. The incident was taken place, my lord, 7-8 days before, my lord. After the 7-8 days, my lord, the informant filed the instant FIR.
Yes, people.
Case diary received, my lord. Injury report is also received, my lord. Injury is grievous, my lord, head injury. And statement of the injured person is also available, my lord. Injured. Yes, incident occurred on 30/11/25. FIR lodged on 8/12/25. And my lord, and why FIR is lodged, my lord, after my lord 6 days, the reason is also there in the FIR. Due to the treatment of my husband, the FIR has been filed.
And it was alleged that, my lord, immediately, my lord, her husband was rushed to the Silchar Medical College, my lord. But, my lord, if any medical report from Silchar Medical College is available or not, man, kindly see. From Silchar Medical College, my lord.
Why is Silchar medical necessary?
My lord, immediately, my lord, he was rushed to the Silchar Medical College.
But before that, he was examined, and because the injury was found to be grievous, he was sent to SMCH.
No, my lord. Initially, my lord, he was taken to Sunapur Hospital. Sunapur Hospital, there is no report, my lord. So far, my
Where is the report from?
Hospital and Research Center, Meherpur Silchar, my lord.
private hospital. My lord.
Consultant neurologist.
Past two hospitals report was not available, my lord.
Difficult to understand the language, this medical language. In SDH, in right, is SDH.
Periphery region, my lord.
Peripheral region, we know what is SDH. Thin SDH. Is it grievous?
Yes, in the type of weapon is also not there. Sounds, my lord, it is.
So what to do now? Call for a report from SMCH.
One medical report is already.
Difficulty following it.
Already settled the matter, my lord, earlier, my lord. Thereafter filed the case.
Third learned counsel for the petitioner. Third learned additional PP. This is an application under. And so. as per the FIR which was lodged on 8/12/2025 by the informant, who is the wife of the injured person, stating that her husband was assaulted from the backside by the accused persons, causing injury to his head as well as other parts of the body with an intent to kill him. Due to the injuries sustained by the husband of the informant, he was rushed to Sonapur Hospital, Hangarpar, and thereafter shifted to Silchar Medical College and Hospital. And thereafter he was admitted to Valley Hospital, Silchar. Is submitted on behalf of the petitioner that altercation took place between the two sides. For what bit? Because of
Basing on the battle nut, my lord, battle nut. Basing on the issue of battle nut loaded truck, my lord.
on the issue of loading of betel nuts on a truck. In course of such altercation, the accused persons also sustained injuries. Also, in this regard, a jury report in respect of the accused person has also been annexed to the instant application. Not injury report, it's an OPD slip. It's not.
My lord, this is our, my lord,
OPD
admission.
slip, not injury report. Okay. Submitted that the accused persons had also sustained simple injuries. Further submitted that the matter was settled in a village meeting held on 1/12/2025. And you withdrew your FIR,
My lord.
after which the petitioners, the accused persons had withdrawn the FIR that they had lodged against the present informant side. However, thereafter, the instant FIR has been lodged by the informant, despite the matter having been already compromised. Call for has been received. An injury report by the hospital Silchar. The petitioner was where the injured was treated after being discharged H. Silchar. Thinks injuries are present on the head of the third person, which have been described as previous. Also said that therein that the after the incident, the patient was oriented. Fact that a compromise had already been the parties. Provided that the petition thousand each. Security of like amount each. Connection with the aforesaid case. Provided that the shall cooperate with invest shall not try to intimidate the bail. This prior bail petition stands allowed. Send back the CD.
Oblige me. 3 petitioners, my lord. Oblige me.
May I please, Lord? My lord, with all respect, my lord, diary is in,
Yes, yes.
yeah, my lord, diary was sought for, my lord. Case of nowadays, my lord, with all respect, my lord. The Abetment in Commission of Section 108 BNS, my lord, which has to fulfill the needs of Section 45 of the BNS, my lord. Earlier 107, my lord. So the FIR, my lord, there are 2 FIRs to be precise, my lord. First an FIR was lost. My lord, let me come to the second FIR, and thereafter both have been merged, my lord. Let me come to the second FIR. Of course, that is the FIR on which the case has been registered, but my lord, the spectrum will show a different aspect. Lordship, would kindly have a look at page 15, my lord. Page 15, my lord. Here, if it is read in totality, my lord, first paragraph is not of much importance, my lord. Second paragraph is of possibly importance, my lord. May I read, my lord? It is worth mentioning that the suicide note written by my daughter before committing suicide was seized by you from the place of occurrence, wherein my daughter fully made accusation against one boy, namely Jitu Dotto, for her suicide. On the basis of the suicide note yesterday, that is on 15/12/25 Monday and 16/12/25 Tuesday, I made inquiry and it came to know that from the last few days, Jitu Dotto, so-and-so, has been physically and mentally torturing my daughter, Nobonita Horma, specifically outside and inside of the campus of National Law Tribunal, Guwahati. National Law Tribunal, Guwahati. Bhavan Panbozar, regarding the same, the staff of NCLT and shopkeeper surnamed Ali, he must have given a statement, my lord, that has to be looked into possibly, my lord. Moreover, this Ali, my lord. Moreover, on last 12, this is of importance, my lord. That is on that date, on the date of the incident evening, Duty Jotto, in absence of other members of our family, entered into our house and also had Nobonita, the deceased, unfortunate, my lord. Moreover, as informed by my friends and my younger son, Jitu Dotto follows my daughter Nobonita all the time and he tortures her mentally in any public place. I was not aware earlier since my daughter did not inform us in this regard, maybe due to fear and threatening of Jitu Dotto. This is the affair, my lord.
Here, my lord, certain things are not stated that, my lord, the boy and the girl, they were in a relationship for around a decade, my lord. The lordship may come to the study at MIT, Calcutta, my lord. And that occurs at, my lord, lordship may kindly have a look our part of the story, my lord. The page 6, para 9, my lord. Page 6, my lord. With all respect, my lord, page 6, para 9. May I read, my lord?
Yes.
With all respect, my lord, that the petitioner begged to state that the petitioner came into contact with the informant's daughter and developed a friendly relationship with her in the year 2015. And subsequently, in the year 2016, they entered into a romantic relationship after the petitioner joined at Amity University, Kolkata, for his higher studies. And the informant's daughter was also a student of the said university. Thereafter, in the year 2019, after completion of these studies, as well as because of lockdown arising out of COVID pandemic, they returned back to Guwahati and they continued their relationship, which was known to members of both families, and they even traveled to different places such as Shillong and Darjeeling, Arunachal Pradesh, and both of them also promised and planned to get married in near future. Furthermore, the parents of both the petitioners and the deceased were well aware about their love relationship, also having good relationship between both the families. It is pertinent to mention herein that the petitioner often used to help the informant side, but it goes on and on, my lord. Thereafter, para 10, my lord, the petitioner begged to state that both he and the deceased has been maintaining their love relationship for the last 10 years without any serious dispute or difference, except some minor trivial issues which do crop up between couples who are in love relationship. But since past few months, the victim's behavior towards the present petitioner gradually started to change, and whenever the petitioner tried to know the reason for her such behavior, she never gave any proper reply. Goes on para 11, my lord, leaving aside 3 lines from the top, my lord, trying to arrange that the petitioner begged to state, this is very important, my lord, that recently the petitioner came to know that the parents of the deceased were trying to arrange their daughter's marriage with another boy, because even after knowing that their daughter and the present petitioner were in a relationship for about 10 years, they were not willing to solemnize the daughter's marriage with the present petitioner, as he belongs to a different caste. My lord, some problem therein, my lord. Thereafter, leaving some lines, upon knowing that the said boy was one with whom the informant side were trying to solemnize their daughter's marriage, the petitioner disclosed the said boy about their love relationship and tried to persuade him not to interfere in the same. But instead of acceding to the request of the petitioner, the said boy initially entered into a verbal argument with the petitioner, and subsequently the same result in physical altercation between both of them. And thereafter, the petitioner returned back home. Goes on and on, my lord. There are petitioner back to state that it goes on and on, my lord. And para 13 also, we have stated something, my lord. Now, question comes, my lord, on the date of occurrence, when unfortunately, my lord, the lady, because, my lord, whatever has been stated in the affair, that part is not untrue, my lord. Again, coming back to the affair, my lord, at page 15, that part is true, my lord. He entered with consent of the parents, my lord. The page 16, last lines, my lord. Moreover, on last 12/12/25, that is on the date of incident, in the evening, Jitu Dotto, in absence of other members of the family, entered into our house and assaulted Nobonita. There was altercation, and, my lord, with all respect, my lord, that may be true, my lord. And the boy was in fact present there, my lord, the new entrant, my lord. And there was some mutual altercation, and thereafter physical violence with both of them, and also Nobonita, my lord. This is true, my lord, on the 12/12. And thereafter he left a suicide note. Prior to here, my lord, one part is missing, my lord, that they were in a relationship. All the families know. Those were not stated, they have not been stated. Now, my lord, the affair which was lost first in point of time states nothing, my lord, that occurs at, my lord, with all respect, my lord, page 23, my lord. 23, my lord. 23. This is the first. The second one would be either 161 or 162 statement, my lord, earlier. 23, my lord, to in charge Malegaon Police Station. Here nothing has been stated, my lord. With due respect, I beg to inform you that today, that is on 13 to 25, my daughter so-and-so on 28 years committed suicide at her residence inside her room while hanging herself in a ceiling fan after closing the door. At around 4:10 p.m., after breaking the door, I noticed her in a hanging position. It is requested your good self for taking necessary steps regarding the aforesaid azahar. This is the first affair, my lord. Same person, my lord, with all respect, lost it, my lord. Thereafter, the second one, this is on the date of occurrence 13/12, and the second affair, my lord, that is lost on 16/12, my lord. Now, of course, my lord, both the affairs have been merged, my lord, and that order is at, my lord, with all respect, my lord, page 32, my lord. And the relevant parties occurs at page 34, my lord. 34, my lord. Accordingly, the lordship may have found, my lord. With all respect, my lord. Both, my lord, UD case and the present affair as a mass together, my lord, and investigation is continuing, my lord. My lord, in the affair itself, in the prayer by the IO, my lord, at page 28, second paragraph, my lord. However, on 16/12/25, complainant Diganta Horma, son of so again submitted a written affair. That written affair read out before your lordship, first in point of time, my lord. So this should be a second affair, my lord. So whatever be it, my lord.
What was you reading just now?
My lord, page 28, my lord.
28.
The prayer by the police by which the prayer for merging both the affairs have been made, my lord. They are in second paragraph, my lord. However, on 16/12/25, complainant Diganta Horma, son of so-and-so, again submitted a written affair at the OP stating that his daughter Nobonita Horma committed suicide, my lord. So this is the factual matrix, my lord. Now, my lord, with all respect, my lord, in the suicide note, definitely, my lord, the incident of 1 day prior hand, with all respect, my lord, that part possibly would be there, my lord. But what I'm saying is this, my lord, the law is there, my lord, even suicidal victims, my lord, with all respect, my lord, exactly same matrix, my lord, that it occurs during 1 day, even if there are cases when it occurred within after 2 hours, my lord. Oh, sorry, not after, my lord, within 2 hours of fact that you go and die. Have I made my position clear, my lord? Mayor, my lord, harassment. The word harassment has been specifically an umpteen number of times used by the apex court that in case of harassment, solely harassment won't do, my lord. It must conform to the ingredients of section 45(5), 45 now, my lord, earlier 107 IPC, my lord, 45 BNS, and thereafter, if those are fulfilled, my lord, harassment itself would not be, my lord, sufficient. The ingredients of 45 are to be fulfilled, my lord. 45 lots is knows, my lord. I'm not to read it, my lord. May I just read once, my lord. 45, my lord, with all respect, my lord. First, my lord, let me come to 118, my lord. Earlier 306, my lord. Section 108, my lord. Section 108, I'll be only reading the head notes, my lord, with all respect, my lord. Abetment of suicide. If any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment of either description, goes on and on, my lord. Abetment of suicide. Now, my lord, with all respect, therein itself, my lord, it occurs, my lord, whoever abets the commission of suicide, my lord. Abetment is defined now in section 45, my lord. Now in section 45, my lord, absolutely, my lord, duplicated, replicated like of earlier, my lord, same version of earlier 107 IPC, my lord. 45 states, my lord, abatement of a thing with all respect and forbearance, my lord. A person abets the doing of a thing who instigates any person to do that thing. If on the day prior hand, my lord, the boyfriend, it is not a case of not marrying the girl. It is the question of asking the girl to sit in marriage, my lord. And thereafter altercation and a one step possibly, my lord, instigates any person to do that thing. Definitely this should not fall within the ambit of instigation to commit suicide, my lord. Thereafter B, my lord, engages with one or more or other person or persons in a conspiracy for the doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing, or goes by either are to be present, my lord. C, my lord, with all respect, any one present would fulfill the ingredients of 45, my lord. Here first is missing, second possibly would be missing, assuming there was physical violence 1 day prior to her death, my lord. C, intentionally aids by any act or illegal omission the doing of that thing, like providing the rope or something, my lord. Those are definitely missing, my lord. Now, my lord, with all respect, my lord, that two things were sought for on the earlier occasion, my lord. The suicide note was not there, my lord. Suicide note was sought for, and my lord, with all respect, my lord, the post-mortem PM report was sought for as to whether there was huge amount of injury, my lord, on the victim, my lord. Because of the incident that occurred one day prior hand, my lord. Thereafter, my lord, if it is necessary, my lord, I'll pay some authorities, my lord. After he reads out the both, my lord, with all respect, my lord. And my friends should oppose it, my lord.
Lord, yes, I have received the case diary, my lord, PM report and everything is there, suicide note. My lord, I have carefully perused the case diary, and from the case diary, my lord, I would like to point out to your lordship, first, my lord, postmortem report. Yes, my lord, initially one, my lord, on 13/12, one UD case was registered by the father of the, my lord, victim deceased. And that at that point of time, one UD case was registered because of the suicide of the, my lord, deceased. And thereafter, my lord, after, my lord, when during investigation, suicide note came later on, my lord. And thereafter, when this later on, my lord, suicide note was discovered, then recovered, my lord. Then thereafter on 16/12, the informant father has again, my lord, lost the second affair on 16/12. Formal affair, my lord. And thereafter, by order of the learned trial court, both UD case and the, my lord, FIR lost on 16/12, both were amalgamated, my lord. And thereafter, my lord, the IO has also, my lord, on the basis of the materials and suicide note, IO has made a prayer before the trial court that this is a case of, my lord, section 108 from the materials available on record, and from the after, my lord, detailed scrutiny of the, my lord, that my lord, suicide note of the deceased, and learned trial court finding materials of 108, my lord, learned trial court has added section 108 of the BNS. And now, my lord, this is the, my lord, victim girl. She is aged about only 28 years. She is a law graduate, my lord, and now, my lord, working in National Law Company Tribunal, my lord. And why, my lord, ultimately, whether the from the case diary ingredients of, my lord, I would like to first, my lord, this is a case of anticipatory bail, my lord, not BA, my lord. So in case of anticipatory bail, at this point of time, it is not required to, my lord, go into every detail. Your lordship has to find only whether the material, prima facie materials to suspect that accused person is the person responsible for ultimately for which the, my lord, deceased has, my lord, taken the extreme steps, that is the, my lord, suicide, my lord. And I would place before your lordship the, my lord, suicide note in detail, my lord. This is not only a case that, yes, there is love relation between the, my lord, victim deceased and the, my lord, accused person. There is that is not unnatural, my lord. Thereafter, my lord, there was also breakup. After breakup, my lord, how, my lord, this accused person continuously mentally tortured, absolutely her life become almost how he affects in her, my lord, internal matters regarding all those aspects, my lord, and in detail in the suicide note, my lord. So this is not only a simple case of suicide along with a detailed suicide note implicating the present accused person for which ultimately she has taken the extreme step of, my lord. So he is the, from the materials available on record, your lordship may kindly peruse the CD and, my lord, suicide note. I have flag marked, my lord, in detail that suicide note, my lord, that is there, my lord, and some of the witnesses of the father, mother, and the other boy, my lord, my lord, my senior has pointed out, was also there at that point of time. His statement, 164 statement, is also available, my lord. And, my lord, from the materials available on record at this point of time, my lord, submission before your lordship that at least, my lord, this is not a fit case for anticipatory bail. While, my lord, a detailed suicide note is already available in there, and on the basis of that 108 added, and, my lord, regarding ingredients of section 45 of the BNS, at this stage, my lord, at this stage, my lord, there are it is not in detail, my lord, every minute detail for attracting section 45 BNS at this point of time, it is not required. For, my lord, consideration of the anticipatory bail at this, my lord, if, my lord, prima facie, there are, my lord, materials to suspect that the accused is the person ultimately for which the victim has, my lord, committed suicide, my lord, that is sufficient for, my lord, rejection of the anticipatory bail at this point.
Yes, I see some other big guns besides learned
Support
PP.
it because suicide note tells everything regarding abetment, regarding instigation, that part is there. On the same night, she committed suicide. Same night, same night.
Same
12.
Next day.
Not next day, night. Same night.
Regarding proximity, my lord,
ঘন্টা
there
তো
is-
চোৱা মই উলিয়াই দিব টাইমটো উলিয়াই দিম I should have
4:30.
been on the other side also.
4:30.
মই তোমাৰ ফালে থাকিলো my lord, what has happened very unfortunate, my lord. The deceased lady, it is related to a friend of our from our own community, my lord. I had been on the other side also, but unfortunately I accepted the brief prior hand, my lord. But anyway, my lord, where, my lord, what my friend has suggested, that is not the law in India, my lord. Because what, my lord, these are sections of law, intention of the legislature, my lord. Somewhere Krishna has said, my lord, he's talking about the philosophy of law. The philosophy of law is to be left to the legislature and in some cases to your lordships, my lord. Because some section of law may be declared ultra vires by your lordships, my lord. Otherwise, the philosophy of law, what is to be taken into account, that section 45 is not to be taken into account in a pre-arrest bail application, that is disastrous proposition of law, my lord. Because Apex Court itself has said, my lord. Now, my lord, Lordship would kindly peruse them at leisure, my lord. What I am saying, my lord, it is not a case that second FIR hides something, my lord. Everyone knows that they were a relationship. Even parents went outside Assam many number of times. Even, my lord, 2 months back also. Suddenly, my lord, we lost the case, my lord, we will not act on it, my lord. Civil Case Act or something, my lord, prevention. Because the marriage was broken because of that thing, my lord. He belongs to a caste, which is, my lord, anyway, my lord, those are not necessary. What I am saying, my lord, what the Apex Court says in such a situation, in a situation like this, wherein death occurs, even after telling the deceased that go and die within 22 hours, what the Apex Court has said, not only one authority, innumerable authorities, and authorities of the Apex Court, my lord, binding on him and me also, my lord, with all respect, my lord. So his proposition law, which is propagating, my lord, it would be dangerous fallouts, my lord. Anarchy will come, my lord. Now, my lord, let me just place it, my lord. In the yes, let me leave the authorities thereafter. Let him say, my lord. Of course, my lord, this is academic. I have got nothing to say anything more on this, my lord. In a situation like this, lordship would, my lord, at this stage during investigation, my lord, I cannot have an access to the suicide note, my lord, with all respect, my lord, if not charge sheeted, my lord. I admit the incident that it occurred 24 hours prior hand or 18 hours prior hand, my lord. In a given situation like this, what has happened, my lord, I'll be very cryptic, my lord, what Apex Court has said, my lord. Let there be any amount of harassment, my lord. Harassment for 6 months, no problem. If it is my lord, proximate, it will be problematic for the defense. It will be problematic for the defense, meaning thereby it will be problematic to the accused to secure relief, my lord. But in the Indian criminal justice delivery system, the law is transparent, clear, and told and retold many number of times that mere proximity, on the top of it, harassment, my lord, thereafter proximity, these two won't be sufficient, my lord. There has to be abatement, because the intention of the legislature is reflected in section 45, my lord. So the ingredients of 45 are to be complete. At the time of giving a slap, say in the instant case, my lord, in that event, the accused must have been having the mens rea that by my slap, I intend that the lady would commit suicide. Can it be, with all respect, inferred from the statement of witnesses, my lord? Definitely not, my lord. Now, my lord, may I just get 2-3 authorities, my lord? I'll be very cryptic, my lord. This is, my lord, IOP 2005. There, my lord, with all respect, my lord. There, my lord, I'll be very cryptic, my lord. Their death occurred upon saying, my lord, more than this. Because here, giving a slap, and thereafter, if the lady commits suicide, my lord, goading her to commit suicide, my lord, would be preposterous, my lord. Here, my lord, what words were used, my lord? May your lordship look at, may your lordship look at para 6, my lord. The gravamen, Lordship may have found, my lord.
Yes.
The gravamen of the allegation was this, that on 2/11, in that given case, my lord, 2/11/22 at around 8 a.m. at the residence of the complainant Uncle Jahar, there are two suicides, my lord. The appellant came there and told the complainant's cousin Tanu, because of you, our boy has died. Why you do not die as well? According to FIR, it was said at 2:11, and thereafter, my lord, with all respect, my lord, according to the FIR, so saying they humiliated Tanu and tortured her, and said that they will file a case against her and also get her arrested and humiliated her in society, so that she will not be able to face anyone in society. According to the complainant, scared of the insult and humiliation by his cousin Tanu, between 10:30 a.m. and 11 a.m., committed suicide, being heard by the statements. It is 8 o'clock, 3.5 hours thereafter, my lord. 2.5 hours thereafter, my lord. She committed suicide because of the humiliation and harassment, my lord. Thereafter, my lord, what the apex court has said, my lord. Lordship, may kindly have a look. I'll be very cryptic, my lord, para 20, my lord. There it is stated, my lord, with all respect and folded hands, my lord, by a long line of judgments, the court has reiterated that in order to make out an offense under section 306, now 108, my lord, specific abatement as contemplated by section 107 IPC. Now it is 45, my lord. I read that out, my lord. Three things, all missing. On the part of the accused, with an intention to bring about the suicide of the person concerned as a result of the abatement is required. It has been further held that the intention of the accused to aid or instigate or to abet the deceased to commit suicide is a must for attracting 306 IPC. Now 108, my lord. Further, the alleged harassment meted out should have left the victim with no other alternative but to put an end to her life, and that in cases of abatement of suicide, there must be proof of direct or indirect acts of incitement to commit suicide. Even if I give a slap, it would not be an my lord, by incitement to commit suicide, my lord. Now thereafter, my lord, the para 22, last three lines, my lord, the utterance attributed to the appellant, you go and die, my lord. Hear me, I'm nothing of that sort, much lesser degree, slap here and there between girls, a girl and boy who are in love with each other, subsequently estranged, my lord. Assuming it to be true, cannot be said to be of such a nature as to leave the deceased Tanu with no other alternative but to put an end to her life. So this is one, my lord. The law is definitely in favor of the present petitioner before your lordships, my lord. Now, my lord, this is another 1995 authority, my lord. There also, suicide took place same day, my lord. Same day. Here it is 1 day hereafter, possibly, my lord. It would be, my lord, there was a quarrel, my lord. Second paragraph, sub-para, leaving aside 3 lines from the top, my lord. On the morning of 13/6/1992, all the three had a quarrel while sharing their morning tea. During that course, the appellant is said to have remarked for the deceased to go and die. The prosecution alleges that thereafter the deceased went home in a dejected mood, whereafter he committed suicide. Thereafter, my lord, next page, leaving aside 2 lines from the top. Those words are casual in nature, which are often employed in the heat of the moment between quarreling people. Nothing serious is expected to follow thereafter. The said act does not reflect the requisite mens rea on the assumption that these words would be carried out in all events. My lord, my giving a slap thereafter she is dying, no connection as such. Besides, the deceased had plenty of time to weigh the pros and cons of the act by which he ultimately ended his life. My lord, during the same day, here maybe during the same day or some hours thereafter, my lord. Thereafter, this is one authority. But law is clear, my lord. 45 ingredients are to be fulfilled. This is also, my lord, the latest, my lord, 2025 4 SAC, Mahendra Awase. There, my lord, date has taken place, Kiman Ghonta. Here, my lord, in between harassment is at 10 o'clock. 10 to 6, my lord. And she died at 6, my lord. There I am reading para 2. Lordship may have the copy, my lord. Mahendra Awase Lordship may have found, my lord.
Hmm.
Awase is para 2, my lord. Living as a same line shown at around 6 p.m. in the evening. This is the, my lord, with all respect, my lord, who I am to put emphasis. This is the suicide note, my lord, at 10:10:22, my lord. With all respect, my lord. And the parting paragraph, my lord, which is prepared on 10:10:22. With all respect, my lord. And thereafter, my lord, framing of charge, my lord, it is there, my lord, para 7. Time is apparent, my lord. On 11:10:22, lordship may have found, my lord. On 11:10:22, between 10 hours to 18, my lord, these are hours, my lord, 8 hours, my lord, from the, my lord, instigation and thereafter death, my lord. And before that, you mentally tortured this is Ranjit Chauhan. He committed suicide, my lord, and what the apex court says, my lord, with all respect, my lord, they are coming to para 23, my lord. Para 23, my lord, that this court has over the last several decades repeatedly reiterated the higher threshold, beautiful language, my lord, mandated by law, section 306, now 108, my lord, with all, and now section 108 given, my lord, read with section 45 of the Nyaya Samhita, both read to be read together conjointly, to be attracted. They, however, seem to have followed more in the breach. Police, my lord. Which is highly, my lord, deprecated, my lord. Section 306 IPC appears to be casually and too readily resorted to by the police, while the persons involved in genuine cases where the threshold is met. My lord, threshold means the ingredients of 45 are to be fulfilled. Thereafter, there can be a full-fledged case, and now under section 108 of the BNS is made, should not be spared. The provisions should not be deployed against individuals, only to assuage the immediate feelings of the distraught family of the deceased. In so clear terms, my lord, with all respect. And 24, my lord, the conduct of the proposed accused and the deceased, their interactions and conversations preceding the unfortunate death of the deceased should be approached from a practical point of view and not divorced from the day-to-day realities of life. Hyperboles employed in exchanges should not, without anything more, be glorified as an instigation to commit suicide. It is time the investigating agencies are sensitized to the law laid down by the apex court under section 306, so that persons are not subjected to abuse of process of totally untenable prosecution, even to the extent of quashing, my lord. All quashed, my lord. And thereafter, my lord, this is Gita. This is also, my lord, 2025. This is within 2 hours. That is within 2 hours, my lord. Para 4. Blow, my lord, here. Blow was given. The present matter pertains to an unfortunate incident that happened on 12/8/28 when the deceased Hoikia, daughter of, goes on and on, my lord. Thereafter, para 4, my lord. Naranka set herself on fire at 10 p.m. on 12/8, my lord. 12/8. Exactly tailor-made like this case, my lord. Parting line, my lord. Yesterday on 12/8/28 at about 8 in the evening, myself and my brother, Sankit and so, and thereafter, my lord, abused her and assaulted her, my lord. Like in the instant case, my lord, that there was a slap here and there, my lord. And thereafter, my lord, parting second paragraph, the above mentioned 5 accused since 6 months have fought with me and abused me in the suicide note. Here also, as has been told, that they were disturbed, my lord, for 6 months, and the last occurrence is 1 day prior hand, but that cannot be, my lord, that you commit suicide. My lord, now para 19 is very important, my lord. Para 18, my lord. There, my lord, with all respect and folded hands, my lord, even if we are to assume that physical blows were administered, will that per se constitute abetment to suicide? My girlfriend at one point of time, now maybe, my lord, estranged because of some other third-party entry, my lord. This line is, even if we are to assume that physical blows were administered, will that per se constitute abetment to suicide? When I gave a slap to my wife, why don't you marry me? You are getting involved with him or her. That sort of conversation, my lord. Would I at that point of time think that my ex-girlfriend would commit suicide, my lord?
I still want to.
when I still wanted to marry her and throw the other boy out, my lord. Kindly see my mental state, very unfortunate. By para 19, my lord. They're leaving aside 2 lines for the same entire paragraph. This court in so-and-so, so-and-so, so-and-so held that in order to bring out an offense under section 306, specific abatement as contemplated by 107 IPC on the part of the accused with an intention to bring about the suicide of the person concerned, and a result of that abatement is recurred. This is the law in India. This is the Indian criminal justice delivery system. It was further held that the intention of the accused to aid or instigate or to abet the deceased to commit suicide is a must for attacking section 306. Thereafter 45, my lord, leaving aside 2 lines from the top. Section 306 IPC, there has to be a clear mens rea, my lord, to commit the offense. It also requires an active or direct act. Here, my lord, not even indirect act. It also requires an active act or direct act which led the deceased to commit suicide. Even indirect act will not do. Seeing no option, and this act must have been intended to push the deceased into such a position that she committed suicide. Now 23, my lord. Applying the test laid down herein above, we are not able to persuade ourselves to hold that when the appellant's family and the victim's family had heated exchanges, there was any intention to abet or cause any member of either family to take their own life. These quarrels occur in everyday life. It happens, my lord, common day occurrence. And on facts, we are not able to conclude that there was an instigation on the part.
We have to conclude now.
I'm sorry. I'm sorry.
Do we take it as concluded?
My lord.
After the breakup, my lord, what is he has done, visited the house of the my lord, and my lord, she insulted the judge. Thereafter, come to the office, my lord, assaulted the girl. After, in fact, after breakup, you are directly involved in my lord, affecting her internal life. How,
My lord, factual metrics will not improve the case. And here, my lord, not 2 hours, 3 hours. Here, my lord, that occurrence entry, my lord, not forceful entry, my lord. They would have informed police on 12th, my lord. That is untrue. With consent, I entered. 12 did happen. She committed suicide on 13th.
All right.
My lord.